I know my audio is muted. I'm trying to let time serve finish because I don't want to miss the end of time served.
Overweight or, you know, lazy. You gotta get the blood flowing every once in a while. So in Judge Goggins' court, he adapted something new. It's very serious. So I just want you to check this clip out and just.
We will. Yeah, I want you guys to finish watching time served right now. I am waiting for that patiently to be done. How is my audio? Hi, guys. Honestly, guys, I feel very sad that I'm not good at timing time served. That's the truth of that matter. Um, I'm hoping most of you have it on because honestly, his stuff is gold. It's great. Here's the truth though. We have people here tonight, and here's what we're going to do. I'm going to go ahead and lay out the plan for this evening, which, if you can see over here, includes bingo. Bingo is it's a fun game that we're going to play. Obviously, no winnings except for fake internet points. They're completely arbitrary. However, what I really want is feedback on it and how you guys think it's going. But you can get in the description below, there's a link to the bingo cards. You can go ahead and get your bingo cards there. We are, however, first going to start with what I would consider hot off the presses, a civilian warrant application. And that's one of my favorites. I'm going to try and squeeze myself in to the hearing as I normally do. I don't know what the size is going to be yet, but we'll get there. Also, if you're just joining us for the replay crew, I'm going to work so hard to actually put the time that we start in the replay or in the comments. I can't guarantee it, but that's what I'm going to work on. Now, um, I also have a very lot of screens in front of me right now. We are working on some different things. So, um, I I was going to tell a story. Here's what I'll do. I'll tell a quick story. Hi, Carol. Thanks for being here. I was just about to tell a story about when I got my tongue pierced when I was young. I was like 18 years old. And well, if you haven't figured it out yet, I like to talk a lot. And I can fill a silence, let's say that. So when I'm working on getting a PO box, me and looking at legal stuff are going to share one because we're so close. But anyway, so my tongue, I went in to get this piercing. I was with two other guys that I worked with, and they were getting something else pierced. The dude he did the regular spiel, then he took me aside and he like reiterated. He was like, "Are you sure? Are you 100% sure that you want to do this?" And I was like, "Yeah, like duh, of course I do." And I am, you know, he goes, "You're not going to be able to talk for a while." And I was like, "Okay, sure." Like, you know how many people have told me not to talk in my life and it's never worked? Never worked. Well, the literal moment the needle was through my tongue, I was like, I made a big mistake. And the reality was my tongue swelled up huge. And I did end up cracking my tooth with it because that's the way life is. Anyways, I do not have my tongue pierced now, but I did at one point. Okay, I hear the time served is done. What an amazing live he had. I I think, I'm all about piercings, all about tattoos. I'm all about whatever adults want to do with their body. You go ahead and do it with your body. And don't you let anybody tell you that you look bad or whatever. Not my place. But just keep it in mind because I also have my belly button pierced. I got my belly button pierced and then I got pregnant and my belly button piercing won't even go away. Like it's always going to be there, I'm assuming. Anyways, guys, if you're just joining us, thank you so much. You are welcome to my kitchen this evening. What we are working on tonight is firstly, get your bingo cards in the description below or beside. I don't know how you've got your thing set up. Secondly, we're going to watch a civilian warrant application. One of those are one of my favorites. That is when a civilian, so a person from the average person on the street, comes to the court and petitions the court themselves without the assistance of a lawyer to have a warrant issued for another person. What this is basically Karen Central. Karen Central. Okay, folks? We have some video footage on this incident tonight, and we also have a ruling. It's a guaranteed ruling. I will guarantee you that tonight to begin with before we get into detention dockets, okay? If any of you are here for the first time, please hit the like or the dislike button, whichever you prefer. That's how we take attendance. Also, ask any questions you might have in the chat. We are a fun place to be. We joke a lot, so don't get scared. We don't bite unless that's what you like. Okay? Also, um, this is actually my kitchen. I get up and do stuff. That's the way it be. But I'm listening and I'm watching the chat and I love to read all that you've got going on. Also, there are points that we give for every 5 minutes that you watch, plus random amounts all over the place. So keep learning and earning your points. Okay, let's continue or let's start with our feature intro for the evening. I don't know, it's the first course. Okay, let's have our first course, and we are visiting DeKalb County, Georgia. DeKalb County, Georgia. And in DeKalb County, Georgia, they do things a little differently, folks. I see you all in the chat. I'm going to be typing soon. Thank you all for being here. Let's go ahead, get this party started. It's going to be a beaut. Let's go. Boom, 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 boom. Okay, we need that bigger and badder.
Clerk, can we put Officer Harris in a waiting room?
Yes, Judge.
Okay, it went through now. It went through again.
All right. All right. Can I have Ms. Butler and Mr. and Counsel? How do I say your client's last name?
Wachuku.
Wachuku. All right, Ms. Butler and Mr. Wachuku, go ahead and raise your right hand. Let me see it on your screen. All right. You swear or affirm to tell the truth, the whole truth, under penalty and perjury of the law?
I do.
All right, excellent. All right, Ms. Butler, what I'm going to let you do now, the time is 6:55. I'm going to give you approximately till 7 o'clock to tell me. And I'm not here about a bunch of background. I want to hear about the date of the event that occurred on August 31st that led to this particular action. Okay.
Yes, sir. I pulled
August
in.
31st. I apologize. 2022.
I pulled. It's like a little shack type aluminum building that you do your emissions. He told me to come in. I came in. He said, sit in that little room. It's a room about 2 feet from my car. I sat in my car and there's a TV there. And I'm wondering what he's doing. He's not pulling the gas cap out, opening the door and connecting nothing. I'm looking at the side of my car. I see his reflection on my car. He was getting a gallon of water. He was wiping counters. He was doing everything. So I stood up out of that room. Then he started doing the procedure. And I'm like, okay, he finished the procedure. Then I said to him, I said, sir, me and him the only one there. We the only two. I said, sir, when a customer comes, you should clean and do what you're doing after you finish. He got irate. Everybody do it. I'm not the only one. You don't tell me what to do. I mean, he blew up on me. I didn't say no more. I pulled the camera out. He said, oh, you don't want to pay me? He went behind my car. He took a picture of my tag. I said, no, I'm going to pay you. I said, that's no problem. He got it in my face. I'm saying, he just, I can't tell you what he's saying. He just saying all kinds of things. I'm not saying nothing. I locked myself in my car. I turned the video camera on. He pointed me in the car. You just pay me. I pulled a $50 bill out. He said, I don't have change. So he walked out of the 10 bill to his personal car. I pulled the camera out because he was already irate. I pulled the camera out. He went to his car to give me change. I'm videoing at his car. He walks back in. You did that. Walks up to me and hit me, knocked my phone on the ground. I videoed all this. He hit me. And I stated, I said, you hit me. I said during in the video. It's 3 different skits, 3 different clips I did. So he jumped in my face in my car. He was arguing with me with my window up. I was scared. You can look at the video. He was, you, whatever he was saying in his other language or whatever he was saying. But when he hit me, that's when I fired. When he touched me, he had no right to touch me no kind of way. We didn't argue. It was all him. It wasn't me back and forth. It was all him arguing. Walked from his car, walked directly to me and hit me in the video. When he hit me, my phone hit the ground and it cut off. And I told the officer this. But we were the only two. It was I think I was the first customer. I guess it can be proven because it was like he just opened up. But he was mad because I told him, you clean after the customers leave, he didn't like me to say that. He told me I ain't gonna tell him what to do. But the reason we're here now is he struck me and knocked my phone out of my hand, and I wasn't gonna let that go by.
Okay. Let me hear from council. You got it. Is that one? I'm sorry. Ms. Butler, you have about a minute left. Is there anything else?
That's it.
All right. Council? I'll give you 7:05.
Yeah, thank you, Your Honor. Good evening to this honorable court. Your Honor, I'll be very brief. Your Honor, this is an alleged incident that is arising from August 31st, 2022. Peter Wachuku has been a successful business owner here in the community for 15 years. He owns and operates a business, an emissions business called Correct Emissions LLC. On the date of this incident, he was owning and operating this particular business. He provided an emissions inspection to Ms. Butler without any incident. She attempted to pay him in a $50 bill. He expressed to her that he did not have change and that she could use a credit card or a debit card or something of that nature. She basically refused to allow the credit card or debit card to be utilized, insisted that it was got to be $50 in cash. So he went and got change from another customer. And she then would not remove her car or move it out of the emissions bay. And then when that did not happen, Mr. Peter Wachuku, the business owner here, he actually dialed and called up 911 himself. When he called 911, Officer C.M. Harris, who is our witness, responded to the location. Officer Harris spoke with Peter Wachuku, spoke with Ms. Butler, actually determined that, and actually looked at a video, determined that there was no assault, determined that there was not any evidence to support that there had been a simple assault from either watching a video or talking to Peter Wachuku or talking to Ms. Butler. He then commanded that Ms. Butler pull her vehicle out of the bay. She pulled the vehicle out of the bay, and she was able to get the difference between the amount that he charges for the admission and the rest of her money. So she got her change. She held on to the money the whole time. It wasn't like he was holding her money as hostage or anything of that nature. And then, Your Honor, after that, the officer determined that there was no arrest or anything was going to be made. And then Officer Harris then issued a criminal trespass warning notice to Miss Butler and advised her to not to return to the location, gave them both incident case numbers, and they went about their way. And this was back again in August of 2022, Your Honor. And after that, Mr. Peter Wachuku hadn't heard anything else about this. He continued to do his business as he's done so for the past 15 years. And then within recent days, he receives this notice in the mail saying that there's an application for a warrant for his arrest that's been filed by Miss Butler. He then came into my office, retained our services. We then sent a subpoena out to Officer Harris, and Officer Harris is here on the platform to be able to give the information that he has to help this court make its determination, Your Honor. So at the conclusion of the evidence, Your Honor, we would ask that this court dismiss this warrant application in favor of the respondent, Mr. Peter Wachuku.
Okay. I appreciate that, counsel. I'm going to give Ms. Butler an opportunity here to introduce any evidence that she may have in support of her position. Now, Ms. Butler, I have yet to get an email from you with any video. Clerk, do you have an email from Ms. Butler with video?
No, sir. I sent her a chat as well, letting her know we haven't got it.
Bear with me, counsel.
Indeed.
Hi, guys. If you're just coming in, welcome. We are watching civilian warrant applications. I'm in the way of the judge. I totally didn't even realize it. We are doing civilian warrant applications. They are waiting on some stuff. The reality is, I don't edit videos that well, so we just sort of walk and talk our way through. If you've been having a bad day, I'm sorry. If you've been having a good day, I'm happy for you. I want you all to remember that every single day before this, though, you've made it through. I promise you, you have every single
Your
one.
Honor, what do I need to do? I see the video and it's
Yeah.
sent to the website. What should I do?
It should be sent if you send it to the appropriate. Are you using the one in the chat box, or are you using one that you already sent to previously? Why don't you go in the chat box and the email address that my clerk has provided? This is the same thing I asked you to do when we first started. Use the email in the chat box.
Okay, this Zoom is totally new to me. So when you say chat box, I'm looking at you. My grandson got me to this point. So when you say chat box, I don't what chat box
There's an
is.
icon that says chat.
Okay, I see that. Okay, I see that. Now what do I do now?
If you click it, you should see the conversations that have occurred, or at least communications that have occurred through the chat. And one of those should be the first email address.
Okay, it says I haven't received it, so can I send it through her right now?
Yes.
Okay, so send to magistrate court, and I go to how you go to anything? Add, let me see, match the add button and file, photo, video, see. Allow.
Counsel, thank you for your patience. I just want to make sure you get this fully addressed.
All right, let's see.
Indeed.
How to do this?
So you would take that email address, that same document that you just emailed or forwarded, just forward it to that email address.
Okay, the reply. Haven't seen your email as of yet, but it's not giving me a. How do you send it? How do you send it? How do you send it?
You would have to attach it. You would have to attach it.
Attach it.
Well, we can't continue now because we got witnesses here. We can't continue now.
Oh my God, I got Bill. The man raced up. He hit me with the phone in my hand, videoing. He hit me videoing, and I done sent it to the. I don't know how to do this. Send to. Okay, send to. How you do it? I don't know. Whose files? I don't know how to do it. Let me go down. Yeah, I wouldn't even be here if I didn't have this, or if he didn't hit me.
Clerk,
Yes, Judge.
Send to magistrate court, but how do you get it to send it? I don't know.
Through your email, Ms. Butler. Your
Put my
email.
email.
That's why you
no,
gotta
not
send it.
your email. The clerk's email.
Okay, it's not showing email, so put the email in first.
This is what we're gonna do.
Yeah, I don't know how to do this, but
Ms. Butler, you just turned your camera off.
oh,
I can see you're panicking. That doesn't help the situation.
okay.
Alright. So listen, counsel, this is what I want to do. And I know you may not like this, but this is what I'm going to do. Ms. Butler, I'm going to give you an opportunity. I'm going to hear Ms. from Cardano real quick. I'm going to give you that opportunity to get me these documents. If you don't have them by the time I get done with Ms. Cardano, then you just don't want to have them.
So how do I get it to you?
I'm going to be honest with you. I'm not IT, you know.
Okay, yeah, me neither. Okay, so I'm gonna send it again to the.
To the address that was in the chat box. So you take, again, whatever email that has the video, you're gonna take that email, press forward, right? Or if you have the video individually, you can just, I don't know what kind of phone you have. But you would take that email, put it into the send space, and then forward it to the clerk. While you work on that, counsel, if you don't mind, I'm gonna hear one other, we only have one other case on the calendar.
Okay,
It will come right back over.
that's fine. Can your staff let Officer Harris know that, that we're.
Yes, clerk, if you can let Officer Harris know just to be patient.
Right.
We
Yes,
have a
Judge.
brief pause in the matter.
Thank
Okay,
you. We'll stand
No,
that.
thank you. Ms. Cardona, go ahead and unmute yourself and turn on your camera.
Done.
All right, ma'am, I've got you under oath. I want to make sure you have any evidence. Do you have any evidence that you sent me? Because I haven't seen it yet. Maybe I have. Hold on, let me see. Hold on. Sorry. All right. Clerk, did you see any email from Ms. Cardone?
yes, Judge. I can go way back from when they first.
The one from today is the one that has the description on how everything happened, because the previous ones I sent, I think I didn't detail out
Now, is
anything.
this evidence or is this your own breakdown of what happened?
Evidence.
Okay.
There's pictures and text messages.
Let me know when you get it, clerk.
They just sent one over.
All right.
What do you guys think the judge is looking at while the clerk is waiting to get this information? Let me know in the chat.
All right. All right. Looking at. I got the first with the photographs. Let's see if there's any others. All right, I got the one thing here with the photographs. Now, Miss Cardona, you're already under oath, so just tell me what happened here.
So that day, I basically was asking him back for my key, for my house key, because he had my house key, and he first he told me that he had gave it to one of his friends. So I called his friend, and his friend didn't even know what I was talking about. And that's when later on he was like, "Okay, I'm gonna go over and pick up my stuff, and then I'll give you the key." So he came, got his stuff, but never handed the key back to me. So he walked that same day that he came and got his stuff. He had asked me if there was something else of his there, which was just the work boots. And he was standing in front of my ottoman that's in front of my bed. So I had grabbed the boots from the closet, tossed them at the ottoman, but it accidentally fell from the ottoman to his hand where he was holding a spiritual something spiritual, and it just hit the spiritual thing, and that's when he got mad and ended up punching me in the face.
Okay. And I see here that you have photographs of your face. When were those taken?
The one that has the bump, that was that same day that it happened, and then where it started getting purple, that was the next day after I woke up.
Okay. And so tell me, I am curious here. I do see that the officer wrote a report. I have reviewed that as well. He didn't determine to make any arrests. It's a very common situation. I hate to say it, common situation where an accused strikes someone and then leaves the scene. When did you call the police? Did you call the same day?
Yes, I called that same day. And then on the email that I sent today, you can see the messages that were exchanged between me and him, after he knew that I was calling the police and that they were headed over.
You said call the cops. Y'all don't use the words, y'all don't use C's.
He doesn't.
He doesn't use C's. Okay. He really goes through that.
I'm sorry. Maybe I'm a little confused. We have to re-rack that? We do. What did he just say? They don't use C's? Is that like a weird form of pig Latin where you take away all the C's from words and then only somebody that knows that you don't see them? This case is confusing. Both of these cases are confusing. I honestly barely can understand them. And I have told you all before, I'm Canadian, but I'm from Scotland and I can understand Glaswegian accents. Um, Anyways, hi to everybody who's here. We're watching a civilian warrant application. This is also in the middle of another warrant application. You guys are just ride here for the ride with me because I've not watched this fully before. I just got this evening when I was getting ready to go live. It is hot off the presses. Um, let's figure it out together. Also, Judge Davis. Judge Davis is like the guy who's become a judge in his 40s and it is nowhere near what he thought his life was going to be. Like, can you imagine the sitcom with Judge Davis where he's like getting ready for his judge day in the morning and like putting on his judge robes and then he has to come and listen to this crap all day long. And he probably dreams of Chirpy, the chirp fire alarm thing. Anyways, okay. Let's continue. I I just love putting myself in their shoes sometimes.
Effort to put X's instead of C's. All right. I mean, the text that I see here, call the cops and obviously identify the lane where he's located.
Mm-hmm.
And the officers just tell me what the officer told you.
So what the officer has stated to me was that they couldn't make arrests in this matter because we weren't living for a month or two together, and also because there's no kids involved. We didn't have any kids, but I told the officer, I know they didn't put it on the report, but I had told the officer that I was pregnant by him.
Okay. Were you able to, well, are you still pregnant?
Yeah, I'm still pregnant, but at that I was probably 3 to 4 weeks pregnant there.
All right. And this happened back in December.
Correct.
Okay. Well, and you're positive that no arrest warrant has been issued and that the officer didn't issue it because he said you guys weren't in a relationship together and you guys
Yes.
didn't do it. All right. Well, that's usually true for family violence battery. But based upon the photographs that are seen here, and sort of for the purposes of evidence, give me 1 second. And I just want to confirm, this is your eye after the incident of the same day?
Yes. Correct. That was the day after. That one right there was the day it happened.
Okay.
And that's when it was starting to like fade away, that one.
Mhm. Okay. So this is what we will do. We will issue an arrest warrant against this individual. We'll also do a stay away order as well. And so that will be the order. Now, this is what you're going to need to do. Because he's not here, a lot of the information that I would normally provide is he's just not gonna, he's just gonna have a warrant. Now, I tend to not like to do these situations, but based upon the allegations, I'm not quite sure why an arrest warrant wasn't issued immediately, but I am gonna issue an arrest warrant for a battery, not family violence battery, but for battery. So what you're going to need to do, and my clerk is going to be able to email you instructions as well. You're going to need to come down to the DeKalb County Courthouse that is off of Memorial Drive. Okay,
Okay.
and that is the one in the building that has the helicopter on top of it. Okay, I need you.
That's off of exit 41, right?
I'm not sure the
Right
exact
by the jail.
number, but it's Memorial.
I'm sorry. Did I miss it? Did he just say the defining feature is that there's a helicopter on top of the building? I'm I'm baffled. I am literally baffled by the whole exchange that's going on. Is my brain not working today? Like I'm hearing it, but I am not. Like what? Fucking since when is it that you look at a building, you're like, oh, helicopter for sure. Helicopter lands on that building. Oh, yes. I am always going to remember that from forever. What? I'm I am seriously a little bit like, does Judge Davis play too much GTA? He's like, I've mapped out the whole city. You can definitely land on top of the courthouse in a helicopter. I told you. Oh my gosh. But if it's a hospital helicopter pad, wouldn't hospital be a better description than building that you can land a hospital or a helicopter on? Anyways. Folks, if you're new here, please hit that like or dislike button. I really don't care. Whichever works. I actually find it really interesting when people hit the dislike button. Leave a comment. Tell me what you hate about me. It's great. I love it. Somebody recently said I was prettier than expected. I was like, expected for what? Based on what? Based on what? I'd like an elaboration. I still appreciate the compliment, but based on what? Anyways, okay. Let's see how Judge Davis goes back to our other lady. Honestly, have no clue what that other lady in bed is talking about. This lady's got vines on her curtains. I need you guys to help me out and figure it out together, okay? Oh yeah, and also get your bingo cards. We're gonna be playing bingo soon.
Memorial Drive and 285.
Yeah.
Yeah.
Okay.
And so you'll come down there, you're gonna have to sign for the warrant as well as the special conditions. I
Okay.
to give you until Friday to achieve this.
Okay.
Because he's not turning himself in.
Okay.
And then once that is getting completed, the arrest warrant will be there. Now, I don't know when he'll be arrested. I'll be honest with you. Because he's not here and he's not, therefore, is unaware of the warrant. And obviously, he can turn himself in if he becomes aware. But at this juncture, I haven't apprised him of any things that he doesn't know.
Well, I know he still has an open case with the cab.
Well, I'm unfamiliar with the open case. But as far as the limited purposes of this matter, I will issue the arrest warrant. And as well, I will issue a special conditions for stay away. So we will do that.
Okay.
And
Do you know, as far as getting a TPO, am I able to do that for him to like
so you wouldn't
not
do
come
that
near?
here. Yeah.
Okay.
But I am giving a stay away. And that is a
Okay.
special condition. It's not a TPO, but it is a stay away. And so it is for the limited purposes of that he cannot be around you. Obviously, he hasn't been apprised of those conditions, but I will put those on the appropriate warrant. And so that's all you need to do is come down to the courthouse. My clerk is going to email you. Clerk, do we have our email address?
I do, Judge.
All right, my clerk's gonna email you instructions, but you're gonna need to come down by Friday in order to sign for this warrant, okay, and these conditions.
Okay.
And then I will sign it. You might want to follow up with an advocate about a TPO, okay?
Okay.
All right, well, you have a good evening.
You too. Thank you.
All right, Ms. Butler and Attorney Matthews.
Yes, sir.
All right, Ms. Butler, I'm looking for your evidence.
Judge, I think she sent it in the chat box itself.
You sent the evidence in the chat box itself. That doesn't help me. I don't see the evidence in the chat box.
Oh, she only sent it directly to me.
Bear with a second.
I don't even know how.
It's technology. It's technology. You know? Not video games. It's now an essential part of your life. You're gonna have to figure it out, Miss Butler. It's like driving a car. If you're used to riding the buggy, you're gonna have to learn to drive. That's just the way we are. Bear with us while we can try to see this out.
Okay, Judge, I just sent you something. See if that works.
All right.
I'm not IT.
Me either. Just JD.
Excuse me. Am I okay to leave the Zoom call?
You are. I'm sorry. I thought I was
Okay.
clear about that. You are free to go.
Sorry.
Please.
Okay. Thank you.
You're well. You're well. It's all good. All right. I think I see it. Hold on. Bear with me, everyone. I just want to make sure I review before I display. Bear with me. I'm reviewing the view. I will share them. Hold on.
Okay.
Come on, IT, finish this. But it's worth it because there's a video. Let me see
All right,
if I
I'll
can.
show you what I got. Oops. All right, I'm going to show the first video, at least try to here. Let me see if I can quiet the video first. All right. All right, ladies and gentlemen, this is the first video that we'll be introducing for Miss Butler, okay? Ms. Butler, take yourself off mute. I want to confirm that this is one of the videos in which you intend to introduce. Is that correct?
Yes, that's where he went to his car and to get my $50 change out his personal car, not a customer, his personal car.
Okay, well, hold on.
Does it have audio?
Move your car. You need to move your car. I'm so serious. And you have no.
That's when he hit me and knocked the phone to the ground.
Okay, bear with me here. I'm going to play the other video here.
This one I was scared of him and I locked myself in my car.
Okay, hold tight. Hold on.
Judge Davis be trifling. He's upset. Oh, here we go.
There we go. All right, next video. I'm gonna restart it. It's a little. Okay. All right. I'm going to show the last video here.
Okay.
No. Sorry, keeps playing. All right.
He hit me. I got it on video. So we're waiting for the police. Oh, yeah. He hit me. I got it on video. So we're waiting for the police. Oh, yeah.
All right. Ms. Butler, those are the videos. Do you have any other evidence and or witness testimony that you intend to introduce at this moment?
No, sir, we were the only two souls there.
Okay. Counsel, and she has no other witnesses or evidence, therefore you are having an opportunity to cross-examine her if you so choose.
Okay, thank you, Your Honor. Ms. Butler, you understand that you're under oath, correct?
Yes.
Okay. Ms. Butler, did you go to the hospital for any alleged injuries that you sustained?
No, sir.
Did you present any pictures of any injuries that you sustained to the Officer Harris, on August 22nd, excuse me, August 31st, 2022? Did you show any pictures to Officer Harris?
Pictures of what?
Any alleged injuries that you claim that you sustained?
These are the 3 videos I showed the officer.
Okay. And did you show the officer any injuries or pictures, or did you hold up your hand or your neck or your arm or anything of that nature to Officer Harris when he showed up saying, hey, this is where I got injured?
When he hit me, it didn't make no abrasion. He pushed into me, but no kind of body abrasions. There was no abrasions. When he hit me, his intention was knocking the phone out. If you hear what he said, you still videoing me? And I wouldn't say nothing, and nothing, whenever he was going off, I didn't say a word.
Did
I
you
just
show,
videoed him. He shot me.
did you show the officer any, did you show the officer your phone on August 31st, 2022?
Yes, I did.
Did you show the officer any area on your phone that you're claiming to have been damaged?
Sir, he just knocked it out of my hand. Fortunately, I got a big, strong case on it.
Okay.
I got a big, heavy case on it. It's the point of him touching me any kind of way, hitting me. He had no right to touch me.
And you told the officer everything that you're telling us today, correct?
Yes, sir.
Okay, and you told the officer that he hit you. Is that what you told the officer?
That's what I said at that moment
And
on
did you
video.
tell, and did you tell the officer, that you were in the emissions bay and that you refused to move your vehicle?
When he hit me, I got in the car and locked myself in and called the
Listen to my
police.
question. Listen to my question, Ms. Butler. Did you tell the officer that you refused to move your vehicle after your emissions inspection had been completed?
I didn't tell the officer. I just didn't move until he arrived. I wasn't gonna get back out the car.
And you agree that Mr. Wachuku called 911 on August 31st, 2022, correct?
If you pull the records, I called first.
But do you agree that Mr. Wachuku did call 911?
I wouldn't know what he did. I know I did.
Okay. And did you see Mr. Peter Wachuku on the phone with 911?
No, I was calling 911.
Okay, so you didn't see him right there. Okay. Did you now on August 31st, 2022, Ms. Butler, you had been to this particular emissions business at least 1 or 2 times over the last 2 or 3 years, correct?
Yes, I have been there before.
And you've been there before because you were pleased with the service that you received before, correct?
I was in a line with other people. It was crowded. He was just getting them out. But this day, I was the only one.
Okay, but that wasn't my question. My question was, over the last 2 or 3 years, every single year for the last 3 years, August 2021 and 2020, you utilized Correct Emissions LLC over here at Redan Road, correct?
21.
Okay, and you did so in 20 as well, correct?
I don't remember if I did.
And on those 2 occasions, Ms. Butler, there was a successful emission. You paid the business owner and you took your vehicle and went about your way, right?
Yes, I've never been alone with him.
Okay. And you you keep saying you've never been alone. So is your position that because you were alone with him that somehow something went wrong?
That's the only reason he wouldn't have did that. If other customers were there, he wouldn't have did what he did.
So let me ask you this, Ms. Butler. You stated that you began to tell him that what he should have done was whatever he was doing with the water that he should have done before you were there. So you were pretty much, I guess, upset or irate with him because he began to wash his hands before he provided service to your vehicle. Is that correct?
Sir, I was not arraigned.
Okay,
By me being a business owner and him also. If a customer pull up, I just told him it's best to do that when the customer leave or before they come. But when a customer there, go ahead and do the admission.
okay.
And
So,
he didn't like that.
okay. So you were basically giving him an instruction on, essentially on how to improve or run his business. Is that correct?
You can say that.
Okay. And you had your $50 out. You gave him the $50 initially, correct?
Yes.
And then he told you he didn't have change and he gave it back to you, correct?
No.
Okay. And then when the officer came, you told the officer your side of the story, correct?
Yes.
And then Mr. Peter Wachuku told the officer his side of the story, correct?
Yes.
And the officer, you would agree, had an opportunity to listen to both sides right there back on August 31st, 2022, correct?
Yes.
And at that time, Officer Harris did not arrest or anything of that nature to Peter Wachuku, correct?
Did he arrest him then?
He did not arrest Peter Wachuku on August 31st, 2022 for any crime, did he?
No, he just gave me paperwork and told me the procedures to do on my own.
And in fact, he gave you something called a criminal trespass warning notice, correct?
That's the paper that's to give you the court information?
No, that's the information that you refused to sign when he gave you a criminal trespass warning notice, correct?
He gave me a criminal trespass. I'm the one called the police.
Right, but you're aware that Officer Harris gave you a notice telling you not to come back to that business location, correct?
Oh, I would not come back. I wouldn't have came back.
But,
He had to get back.
but you agree though that this document here called a criminal trespass warning notice, you refused to sign it when Officer Harris presented it to you, correct?
Refused. I just received it. I didn't know I had to sign.
Right, but Officer Harris asked you to sign it, remember?
Are you saying have I been bad? I haven't been bad.
That's not what I'm asking you. What I'm asking you is the officer, listen to my question. Officer Harris, on August 31st, 2022, he presented you with a document that I'm holding up called criminal trespass warning notice, asking you to sign it so that you can have notice that you're not to come back to that business, correct?
Well, you have to give me a moment so I can get my document so I can read it. I cannot see that.
No. Okay, I understand that.
I have the same document. I can go get it.
Your Honor, we sent this information to Your Honor. Would Your Honor be willing to put it up on the screen for
Absolutely, bear with me.
Thank you.
Bear with me while it loads.
May I speak, Your Honor?
Bear with me here. Let me introduce this. Let me get this in here. Bear with me. All right, Counsel.
Okay, so Ms. Butler, on the screen here, you see it says criminal trespass warning notice. You see that?
Yes,
And your name is LaShawn Gazelle Butler, correct?
yes.
And the date on it you see is August 31st, 2022, correct?
Yes.
You see the time was 10:44 a.m., correct?
Yes.
And you understand that you see where it says witness Officer C. Harris there, badge number 3355. You see that?
It's showing half the paper, you know that.
Well, I'm just saying where it says witness, where it says Officer C. Harris. You see that?
Okay.
Do you see it?
It's blurry, but I believe you. Go ahead.
Okay.
It's blurry.
All right. And you received, Officer Harris actually gave you this document on August 31st, 2022, correct? He gave it to you, the officer did. And he asked you, Officer Harris asked you to sign that document, acknowledging that he handed it to you. You remember that, right?
He said both of us received.
Right, but listen to my question.
Okay.
Sir Harris, he asked you to sign that document when he was handing it to you, correct?
And I asked him, do I have to? And he said, no, you don't. And that was the end of it.
Right. So he asked you to sign it and you refused to sign it, correct?
I asked him, did I have to? He said, no. So that was the end of it right there, just like that.
So as a result of that, you did not sign it, correct?
When he said I didn't have to.
Right. And you see that Peter Ochukwu, you see his name there, correct? Where it says Peter? That signature, you see that signature where it
Yes,
says,
I do. Uh-huh.
and you see that Peter, you watched him sign that document.
No, no,
Okay.
no. I didn't watch him sign no document.
Okay. But you were handed a copy of this document by the officer, correct?
Yes, I did.
And you can read and write, correct?
Right.
And you read that document, correct?
Right then and there.
Well, at some time
I
after
asked him,
that,
what was this? It's just something that you're not coming back. I said, well, I'm not coming back anyway. And I said, do I have to? He said, no. And it wasn't no big deal. That was the end of it. He didn't say you had to, if you anything else, nothing else.
and Ms. Butler, you understood that when you received this notice, and after you having read that notice, you understood that it meant that you could not come back to that location again, correct?
Yeah, without that notice, I wouldn't come back anyway.
Right, and you understand that if you were to come back to that notice, to that business location after receiving this notice, that you could be arrested for criminal trespass, correct?
That's fine. I would never come back.
But you understood that though, correct?
That I couldn't come back there, correct?
That's right.
Right.
Okay. And you haven't been back since that location, since that time?
No, not there.
And you've been complying with this criminal trespass warning notice as a result, right?
I've been complying.
You have been complying with this notice, correct?
Right, not to his business.
Correct. All right. Judge, you can take it down. Thank you. Now,
Counsel, I'm gonna give you about till 7:45, all right?
okay, I'm almost done. And all of the videos that we just looked at here this evening, Ms. Butler, those are the same videos that you showed Officer Harris, correct?
I think I showed him one.
You only showed him one video on that time, but you had
at that point in time, the only thing was important to me, him seeing him strike me.
okay. And is it your testimony that in the videos that we've seen here today, that it shows someone striking you? Is that your testimony before the
Absolutely.
That's what you're saying the video shows?
Absolutely.
Okay. So if I told you that I did not see any evidence of anybody striking you in any of those videos, you would disagree with me, correct?
You can hear it hitting me. You can hear him hitting me.
That wasn't my question, Ms. Butler. I asked you whether or not, if I told you that I did not see anyone striking you in the videos that you showed, you would disagree with me, correct?
I would tell you to look again.
Okay. That's all I have, Your Honor. Thank you.
All right. All right, well, Ms. Butler, give me 1 second. You've presented your evidence. I am going to give an opportunity for the respondent to produce any evidence or testimony that they have. So, counsel?
Yes, Your Honor. I'm going to ask that we bring Officer C.M. Harris, badge number 3355, as a witness for the court's consideration.
Clerk, fine. Clerk, can you bring the Officer Harris in for the breakout room? All right, officer, let me go ahead and get you under oath, okay?
Yes, Your Honor.
Right hand. You swear affirm to tell the truth, the whole truth, under penalty of perjury of law?
I do.
Excellent. Counsel.
Thank you. Officer Harris, good evening, Officer Harris, and thank you for appearing before this honorable court. Officer Harris, how are you employed, sir?
I'm employed as a DeKalb County police officer at East Precinct.
And Officer Harris, how long have you been an officer?
Approximately 8 years now.
Okay. And I want to ask you, do you have experience as a uniform patrol officer here in DeKalb County?
I do.
Okay. And Officer Harris, I want to direct your attention to August 31st, 2022. Did you receive from dispatch a 911 call directing you to, or directing an officer to respond to the address of 4800 Redan Road, Stone Mountain, Georgia?
I did.
And Officer Harris, can you tell this court, did you prepare a police incident report in connection with being a first responder to this particular 911 call?
I did.
All right. And as a result of receiving the call from dispatch and showing up to 4800 Redan Road, Stone Mountain, Georgia, tell this honorable court, if you would, what did you find the circumstances to be upon arrival?
So upon my arrival, I met with both callers that called into 911, which will be Miss Butler and Mr. Nawachu. Let me say if I'm pronouncing that correct. Last name.
Wachuku.
Wachuku. Miss Butler and Mr. Wachuku. It was a dispute in reference to the service at the correct emissions, which is Mr. Wachuku's place of business. I met with both parties and spoke with both parties. The first person I spoke with was Miss Butler, whose vehicle was still in the bay of the emissions. And Mr. Wachuku wanted her to move her car out of the emissions bay so he could continue serving other customers. Miss Butler moved her car out of the emission bay, and I spoke with Miss Butler. And Miss Butler stated that she arrived to the location to receive the emissions done on her car. And after that emissions was done, stated that it cost $25 and that she had a $50 bill and that she was waiting on her change, and that Miss Butler stated that Mr. Wachuku came back to the vehicle and got in her face and slapped her phone out of her hand, knocking her phone out of her hand as she was recording. She stated that she called 911. I then spoke to Mr. Wachuku. Mr. Wachuku stated that Ms. Butler arrived to the location for an admission, and he advised after he completed that admission, Ms. Butler gave him a $50 bill. Ms. Butler gave him a $50 bill, and that he told her that he did not have change for that $50 bill and that she could pay with the card. Mr. Wachuku advised that Ms. Butler became upset and irate and stated that Ms. Butler began recording and refused to move her vehicle so he could provide service to the other customers. I did observe the video footage on Ms. Butler's phone, and the footage that I observed, you could see Mr. Wachuku approach Ms. Butler, telling her to leave. I then observed Mr. Wachuku near the camera, and the footage stops. And that's all I observed on the footage. I didn't get to see exactly what occurred before that video footage stopped.
When you looked at the video, did you ever see Peter Wachuku knock a phone out of the hand or anything of that nature?
I could not see that before the video footage stopped.
Did you ever see the phone go down to the ground?
I just saw the footage stop from my recollection.
Okay. When you arrived, did you see other cars waiting in line as though they were going to get their emissions done on that day?
I did. It was a vehicle directly behind Miss Butler's, and if my recollection could, if I recall correctly, it was another vehicle behind that vehicle.
Okay. Did you see any scratches or scrapes or any injuries on Miss Butler in any capacity?
I did not.
Did you see any damage or shown any damage to a cell phone of Miss Butler?
I did not.
Did she tell you that her phone was cracked or damaged or anything of that nature?
No.
Did she tell you, or do you remember it having this very uh, tough phone casing to it, or do you remember?
Phone casing, I do not exactly recall how the phone casing looked.
Okay. And as far as the $50 bill or what have you that was involved, did you see or determine how she actually ended up making or paying for the service?
I remember that I spoke to both parties and they were able to get the money situation handled amongst themselves. Ms. Butler did pay for the service.
Okay. And did you ask Mr. Wachuku, did he ever put his hands on Miss Butler or on her phone or anything of that nature? Did you ask him of that?
I did.
And what was Mr. Wachuku's response when you asked him that question?
He denied ever slapping or hitting her phone.
Okay. And did you speak with any other drivers who had their cars out there to do emissions, get their emissions done? Did you talk with any of them to say, hey, did you all see any of this happen?
I did not.
Okay. And you have, obviously, as a uniform patrol officer for DeKalb County, Georgia, you have arrest powers, correct?
I do.
And that's because you're post-certified, right?
That's correct.
All right. And as such, did you believe at that moment that you had thoroughly investigated this particular call on that particular morning, August 31st, 2022?
I did.
And as a result of that investigation that you conducted, well, let me, before I ask that question, do you have prior, in the 8 years that you've been on the force, do you have prior experience with handling dispute calls between business owners and customers?
I do.
And do you have experience making investigations when dealing with disputes between business owners and customers?
I do.
Okay. As a result of this particular dispute call and the investigation that you did on this particular morning, did you find there to be any probable cause to make any arrest on Peter Wachuku for any crime of simple assault, simple battery, or any other criminal charge that's on our books here in the state of Georgia?
I did not.
Now, at some point, Officer Harris, did you issue to Ms. Butler a criminal trespass warning notice?
I did.
Can you explain to the court what is a criminal trespass warning notice and why did you issue one to Ms. Butler?
A criminal trespass notice is a notice from that business. It can be from the owner, it can be from a manager or employee. When a customer has a dispute, or if it's an arrest or an incident that occurs at that location, if that business no longer wants that customer to come back, they have the right to criminal trespass that customer from that location. And the criminal trespass warning notice is a notice stating that that business no longer wants that customer to return to the location. And if they do return to that location, they could be subject to arrest.
Okay. And did you issue one to Ms. Butler on August 31st, 2022?
I did.
And when you issued that criminal trespass warning notice to Ms. Butler, did you ask her to sign the notice acknowledging that she's read it and she understands it and that you were handing it to her?
I did.
And then when you asked her to sign it, did she refuse to sign the notice?
I believe she signed it. Yes.
Did she? I want you, Your Honor, can you put it up on the screen for Officer Harris so that he can refresh his recollection as to
I
whether?
can, but I'm going to tell you, counsel,
Okay.
we're well over time.
Okay, I got you.
Time, but we're well
Okay.
over.
Okay, I got you.
Hold on.
Oh, I think I got a copy as well. No. For my recollection, I just
Right
pulled
here.
it up.
It's right here. It's right here.
Okay.
Is this the criminal trespass warning notice that we're referring to, Officer Harris?
Yes, it is. It is.
I see here where it says refuse to sign. Is that a refusal to sign by Ms. Butler?
It is.
Okay, and is that Peter Wachuku's signature?
It is.
Okay, and finally, Officer Harris, is there any, did that conclude your involvement in this particular case?
After I provided both parties with case numbers, that was the conclusion.
Okay, thank you, Officer Harris. I have no questions further for Officer Harris, Your Honor.
Excellent. Ms. Butler, do you have any questions for Officer Harris?
There's some discrepancy, but they're not major.
Yes, no?
Okay, the amount was $20.
Well, you gotta ask them a question. You can't testify. So you want to ask the officer any question? Or?
Okay. Yes, officer. What's your name?
Harris.
Officer Harris.
Officer Harris.
You had a superior with you. I call him Dimples. He's a senior in DeKalb County. And I said, how you doing? But you had a superior with you. And did you? Two cars pull up. You had a superior, the one that looked over.
He also responded to the.
Yeah,
he
had
wasn't
said
my direct supervisor, but he was a sergeant working in the area.
Yeah, and while we was talking, he said, this was your call. He said he's just there to see if everything going right. But that's what he said. This was your call, not his. He was just there to, I guess, see if everything working right, or I didn't know if you were new or what. But I had showed you the video, and I repeated 2 or 3 times, but you said I don't see it. But nevertheless, you did say that. The paper you had me sign. The paper you had me to sign. I said, do I have to? And you said it's up to you. Then that's when I didn't sign.
So hold on. So you're asking him a question? Because right now your testimony is ask him the question.
Okay. See, I don't know how to. Okay, so I said I asked you, did I have to sign it? And I don't know how to word this. I asked you, did I have to sign it? You said no, so I didn't sign it. I didn't know what big a deal it was because I wasn't coming back.
Hold on, Miss Butler. I hate when I have to do this, but ask him a question. Did you not tell me that it was optional? Or
okay, I didn't know how to word it.
Okay.
When you had me to sign it, I said, "What is this?" I said, "It's for you not to come back." I said, "Well, I ain't coming back anyway." Do I have to? Did I ask you? Do I have to sign it?
Yes, you did ask me. Did you have to sign it?
Right. And your answer was
that it was up to you if you wanted to sign it or not.
Yes, sir. That's it. That's all I have. That's all I have.
Okay, you have no other questions for this officer?
No, sir. No, your judge.
Councilman redirect?
No, Your Honor. No.
All right, thank you so much, Officer Harris. I will let you go.
Thank you, Officer Harris.
Thank you, Your Honor. Thank you.
Thank you.
Counsel, do you have anything else before I let you guys do a closing?
1 second, Judge.
You may be excused, Officer Harris.
Thank you, Your Honor.
That's all we have, Your Honor.
All right, well, I'm gonna do a small opportunity here for folks to close. So I'm gonna go ahead and give Ms. Butler an opportunity to state why she believes an arrest warrant should be issued.
Yes, something that was very simple, just to pull in, get my admission and leave, end up to be tremendous. No matter what is said, if I told you, see about your customers, that should have been it. You do not have the right for a business to walk up and put your hands on nobody. That's the reason I wrote this. That's the reason I put this in for, put this warrant out for him. If he touched me, he either hit somebody before me or he will after. I'm not irate, I'm not cursing, and he put his hands on me because we was the only two there. He just walked right up and hit me. You can see him walking to me. You don't hear me saying nothing. That's what it shocked me. I couldn't believe it. I didn't want to let it go. And maybe he'll think twice, another customer come through, that he would not put his hands on nobody. Put his finger in their face, hollering at them. I just had to speak up so it won't happen again for somebody else. That's it.
All right, counsel.
Yes, Your Honor. Thank you for extending a little diligence, a little deference to us and giving us an opportunity to have a proceeding this evening. Your Honor, you've had an opportunity to hear from Ms. Butler. You have an opportunity to hear from Officer Harris. Officer Harris has been a DeKalb County police officer with experience on the force, handling dispute calls between business owners and customers for a significant period of time. He came out to the location. Ms. Butler showed him one video, not three. Your Honor has had an opportunity to see these three videos. None of these videos show Mr. Peter Wachuku striking her phone or anything of that nature. On the date of this incident, Officer Harris did not see any type of striking of the phone, striking of her hand or anything of that nature, as he testified to. Mr. Peter Wachuku actually called 911. If he was the primary aggressor, if he was committing crimes, I'm not sure why he would want to call the police to the location and get himself into a problem situation if he's actually committing crimes. He called 911. He's been a 15-year business owner in this community. He was operating his emissions business, and when he was doing so, apparently Ms. Butler did not want to move her vehicle after he performed the emission. There was not an issue concerning the amount of money. There was no issue concerning whether or not she had the money to pay. There was no issue along those lines. She tendered the money to Mr. Peter Wachuku. He said he couldn't make change. He wanted her to use a card, and then he gave her the $50 back. And then at some point after that, he was able to get change to her, but she still wouldn't move the vehicle until Officer Harris showed up. When Officer Harris showed up, Officer Harris talked to both of these folks, and in talking to both of these folks, he's not able to determine any probable cause here that a crime had been committed by Peter Wachuku. He then, if Ms. Butler is the alleged victim in this case, then why is he issuing a criminal trespass warning notice to her? And what's telling, Your Honor, in terms of the mindset of these folks at this particular location on this particular date, is who was compliant and cooperative with the officer. Well, Ms. Butler, when she received this criminal trespass warning notice, he asked her to sign the notice. She's asking, do I have to? Do I have to sign this? She wouldn't sign it. But she received a criminal trespass warning notice telling her, hey, look, don't come back to this business location. So I think that is quite compelling and telling of what really was going on out there. These folks have no reason to deal with each other in the future. There are hundreds of emissions businesses in DeKalb County that she can take her car to in the future. She'd been there at least 1 year before, and there was no issue at all. but for this particular day, she had all these issues with this particular location. So, Your Honor, I'm asking that this application be dismissed. They go about their separate ways. This is from August of 2022. There's been nothing that's been going on between these folks since, Your Honor. Thank you.
Thank you. All right, well, folks, let me just first, again, thank you and being cordial to each other as we proceed today. Obviously, I'd like to address the overall concerns. Folks presented some evidence here. Obviously, we had the officer, but there was no clear evidence here that they were actually struck. Obviously, there was a disagreement, but I didn't see any battery. Obviously, folks have disagreements, and the police were called and did not seem, nor the officer at the time, felt the necessity to issue an arrest warrant against either party. The criminal trespass notice in and of itself isn't any indication of whether or not a battery occurred or not, but I do understand with him being the business owner, that would make sense. But obviously that in and of itself, though, does not indicate whether or not he struck her. But the evidence just doesn't show that that happened. And as a result, we're going to deny the application. And that's going to be the order of it.
Thank you. Thank you very much, Your Honor. I do apologize for being a little long-winded. You know how we lawyers go, Judge.
Yeah, but you're all right. We'll work it out. You're only other case.
Well, there you have it, folks. That is the end of that civilian warrant application. And was anybody surprised about what happened there in terms of what was put in place and what wasn't? Just give me one moment and I'll get our main event lined up here. We have still probably space in the description for you to get your bingo cards. We are going to be playing Detention, Docket, Bingo. And your bingo cards are all a little bit different. Remember, this is all for fun. And so don't get all sad. If you don't win, that's just the way it is. Anyway, give me one moment here. I'll pull this up. In the meantime, please take the opportunity to go subscribe and hit the like button, please. And thank you. It'll just be one more moment because I'm slow, but that's okay, guys. Anyways, also, I really enjoy hearing about how you do your egg sandwiches. Everybody do yours different. That's okay. Okay, here we go. Let's bring it on. Get your bingo cards ready. What I want you.
Metro Care, the family resides in Dallas, or Malas and Garland, Dallas County. The group home is in Tarrant County, Fort Worth. I talked to.
Sorry, she jumped ahead of me there. Crazy lady. Crazy lady? No, that's not what's happening. Okay, first things first. I want you to get your bingo cards ready, and we are going to see what you've got, and then we are going to remember the middle space is free. It's a pre-trial space.
Bernie, I don't. Oh, there it is. Yeah, they just turned it on. Thank you.
Thursday, December. Good morning, everyone. It is Thursday, December 17th, 2020. These are the detention hearings for the 323rd Judicial District Court of the State of Texas, designated Juvenile Court for Tarrant County. Pursuant to emergency orders 1 through 30 issued by the Texas Supreme Court, the courthouse is generally closed to the public except for essential hearings. However, in keeping with the spirit of the open courts provision of the Texas Constitution, These hearings are being broadcast live on YouTube. Anyone who may be watching on YouTube, I will let you know that recording or rebroadcasting all or part of these hearings is expressly forbidden. Violation of the court's order may subject you to civil and/or criminal contempt proceedings. First on the docket this morning is Mohammed Ahmed. Are you Mr. Ahmed?
Yes, sir.
Mr. Ahmed, my name is Judge Porter. The law says when you're brought into detention, you must see a judge within 2 business days. This is your initial detention hearing. You have the right to remain silent. You also have the right to an attorney. And I have appointed Janine Hopkins as your attorney. Is Ms. Hopkins here today? All right, for purposes of this hearing, Ms. Taylor, are you willing to help out and represent the respondent for this detention hearing?
Yes, Your Honor.
Thank you, Ms. Taylor. All right. Mr. Miller, what brings Mr. Ahmed to court today?
Your Honor, on the 15th, his father had called and said that when he got home from work, he was not in the apartment and that he believes he was hanging around the apartment complex and did not return back to the home till 11:30. The following day, Dad attempted to take him to the DAP because he's been skipping classes at school, and they placed him in DAP for 3 days. When he tried to get him into the DAP, he refused to go to school. Dad tried for about an hour to get him in there. He refused to go. Dad brought him back home. Dad left to do some work, and when he came back home around 1:30 or so, he discovered Muhammad was not there, and he had not given him permission to go anywhere, and I didn't give him permission to go anywhere. When I checked with the EM office, they located him at Brown Trail and 183. Not his home.
And he is currently on probation, is that correct?
Yes, Judge.
And one of the conditions of his probation is both that he stayed home and not have any unauthorized absences from his home, and that he is to attend school dutifully and engage in his studies as directed. Is that correct?
Yes, sir.
All right, Mr. Ahmed, this makes it easy for me. If you don't want to go to school out in the free world, you can go to school in detention. So I'm going to order that you be detained today. Thank you, sir.
That's all, sir.
All right.
Thank
Victor
you.
Alvarado.
Yes, sir. Thank you for coming, sir. No parent on this, Your Honor.
All right, thank you. Is Mr. Alvarado here?
Yes, Your Honor.
There we are. All right, Mr. Alvarado, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney. And Mr. Youngblood, your attorney, is here to represent you. You see Mr. Youngblood on the screen?
No.
Hello?
Oh, yeah.
All right. The court has previously found that probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your detention. I will note that you are level 1-0 in the back in detention and have been since the 8th. However, the basis of your referral was aggravated assault with a deadly weapon and also currently pending on a charge of murder. Based on the gravity of the offense, based on the fact that there's not a parent or guardian here to release you to, I'm going to order your continued detention. Thank you, Mr. Alvarado. That will be the order of the court.
Thank you, Your Honor. I have a question for the PO. Did we hear from Mom?
No, but I will say this. Originally, this client had a detention hearing on the 8th. I received a notice that his next detention hearing was scheduled for the 21st. It wasn't until I saw my email this morning that it shows that he was scheduled for a detention hearing today. After speaking with Ms. Kelleher, she had indicated to me the possibility that Judge Kim had scheduled the hearings a little bit earlier due to the holidays and wanting cases spread out. So Mom's understanding is the detention hearing was to take place on the 21st.
Okay, well, if you hear from her that she would like to be present for one, I imagine Judge Porter or Judge Kim would be happy to set her another one sometime before Christmas, but I don't know that.
Okay.
Thank you.
Thank
Thank you, Your Honor.
All right, thank you, everybody. Ryan Allen Dahl. Are you Mr. Dahl?
Yes, sir.
Am I pronouncing your last name correctly?
Yes, sir.
All right, Mr. Dahl, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and Mr. Decker, your attorney, is here to represent you. Do you see Mr. Decker on the screen?
Yes, sir.
All right. Mr. Miller, what brings Mr. Dahl to court today? Is Mr. Miller still here?
Judge, he's this is his second 10-day detention hearing. Ryan was previously released on EM back in June by Judge Terry. About 4 days after that, he had removed his EM and absconded and was on the run for approximately 5 months. One of our concerns is he was out there posting on social media with assault rifles, and he's pending a burglary of a building and the transfer disposition of an offense of deadly conduct.
All right, Mr. Decker, what are your thoughts?
Well, he has been in since now before Thanksgiving. The living situation has changed a little bit in that his mother and his grandfather are living together, where previously he was only with his grandfather, who, when he left during the day to go to work, Ryan was basically unsupervised, and that would not be the case at this point. And no petition has actually been filed since he's been in custody recently. So we'd ask for him to be able to go home to his mother and grandfather at this time.
Judge, the petition was filed back in June.
Let's see.
Your Honor, this case is actually in my name, and there is a petition filed for the motion to modify as well as the transfer hearing.
All right.
Oh, yeah, from June. All right. Sorry, I see it. I have it.
Mr. Dahl, the fact that you cut your monitor off just 4 days after Judge Terry gave you a break concerns me very greatly. That's the first thing. The second thing is you're on the run for 5 months. Third thing, Mr. Miller's telling me that there are social media videos of you with weapons. That really, really scares me. Those 3 factors combined lead me to believe at this juncture, right here, right now, that I can't yet trust you if I were to release you today. However, if you keep maintaining level 1.0 in the back, eventually those 2 things are going to balance out, and I might be more inclined to release you, but I can't do it yet. I don't feel safe yet doing so. So I'm going to order your detention today. That will be the order of the court. Thank you, sir. Thank you, Mr. Decker.
Thank you, Judge. Am I free to go?
Yes, sir. Thank you. Good to see you.
Good to see you.
Caleb Dickerson. You, Mr. Dickerson?
Yes, sir.
All right, Mr. Dickerson, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge within 2 business days. You have the right to remain silent and not say anything at all. You also have the right to an attorney, and your attorney, Mr. Adeniji, is here. Do you see him on the screen? White shirt, red tie?
Yes.
All right. Is Ms. Turner Hill here today?
Yes, sir, I'm here.
All right. What brings Mr. Dickerson to court today?
Caleb was referred in custody yesterday for aggravated assault with a deadly weapon, assault against elderly disabled individual ×2, assault bodily injury, and criminal mischief 100 to 750. According to the report, police were dispatched to a disturbance at a group home. The caller advised that Mr. Dickerson was assaulting residents and had a knife. When police arrived, they observed Caleb at the front holding a knife. They also observed a van, which was the group home van. The window was broken and a folding chair was on the ground. Caleb threw the knife at the officers and he was detained. The group home nurse, who was victim 2, told police that when Caleb woke up, he was in an agitated state. He began to hit victim 2 in the arm, causing pain. She shut her door and called 911. Caleb then began assaulting other residents. Victim 1 is a 64-year-old male. He was cut several times on the top of his head with a knife. Victim 3 is a 24-year-old male, and he was struck in the head several times. Victim 4 is a 41-year-old male. He was struck several times in the face with the fist, and then victims 1, 3, and 4 disabled. Victim 1 and 4 cannot speak. After assaulting the victims, Caleb went outside and broke the window to the van, which was valued at $600. He was arrested and transported to JDC. His mother is on, and also Miss Paula Reed is from Metro Care. The family resides in Dallas, or mom lives in Garland, Dallas County. The group home is in Tarrant County, Fort Worth. I talked to Ms. Pickens, who's the social worker at the group home. She says that if the court was to release Caleb, that they would need at least 24-hour notice so they could try to find an appropriate placement for him. They are concerned about his behaviors and his mental health. His mom says that Caleb suffers from IDD and autism. He is almost 32 years old, but cognitively he's at a 3rd grade level according to the parent.
And mom is here.
Yes, sir. Brandy?
Yes.
All right. Randy, when's the last time that Caleb saw a doctor?
What type of doctor?
A psychiatrist.
I don't know, since he's been in a group home. I know that last week he was in JPS and he's seen their psychiatrist.
All right. Do you know whether he was prescribed any medication at the time?
He's on medication. He was on medication before he went.
Okay. And so that medication, when was that medication prescribed?
Originally?
When is the last time he received a new medication prescription? What date?
I honestly don't know, sir, because he's in a group home and they take care of those things.
Your Honor, if I may, Ms. Pickens says that the psychiatrist hadn't had a chance to assess Caleb, but mom told me this morning that he is on 4 medications. The medications are at the facility, and so if Caleb is detained, then we'll make arrangements to get them to him in detention.
All right.
Does he have a caseworker?
He has a social worker with the group home, and then Ms. Paula Reed is his caseworker through MHM or Metro Care in Dallas.
Because they'll be able to answer all the questions the judge is asking.
What are your thoughts, Mr. Adeniji?
I leave that in your hands, Judge. This is not it. You know, I mean, I think somebody's feeling Caleb.
All right. Mr. Dickerson, based on the gravity of the offense or offenses, I'm going to order your detention today. I'm also going to order that we schedule a visit with a psychiatrist back in detention so that the psychiatrist can assess your needs. Since we don't have a concrete date for his last examination, let's go ahead and get him in line for that. And then Ms. Turner-Hill, if you can reach out to his caseworker and have those medications that he's currently on be brought to JPD.
Okay, yes, sir.
All right. Thank you, everybody. That'll be the order of the court.
Thank you, Judge.
Thank you, Mr. Adeniji.
May I excuse, Judge?
Yes, thank you so much. I appreciate it.
Thank you.
Damian Lamont Elliott.
Yes, sir.
Are you Mr. Elliott?
Yes, sir.
All right, Mr. Elliott, my name is Judge Porter. The law says when you're brought into detention and detained, then you must see a judge every 10 business days thereafter. But this is an attorney-requested detention hearing. You have the right to remain silent. You also have the right to an attorney. And is Mr. Adler here?
I am, Your Honor.
All right, Mr. Adler, help me out. What's going on?
Judge, very briefly for some medical confidentiality, can you please read page 3 of Ms. Rodriguez's report, what's in bold? It's a very short paragraph, and then we can have a discussion. Thank you.
Okay.
If I may add a couple things, Judge.
Yes.
So I think it was last week, Judge Kim allowed him to go to his appointments with his mom on the electronic monitor. He did really well on the monitor. And Judge, just one last thing. He has, I think this family is now going to reside in Dallas County. He basically has the same referrals and the same charges in Dallas County as he does Tarrant County. So whichever county was going to adjudicate and disposition him, I've kind of have very loose verbal agreements that the other county is going to dismiss their charges. It just happened. It has not happened. I'm his attorney in Dallas County also, and we are set January 14th, I believe, just for the court's information. And that's why I would ask that he be released to his mom today.
Ms. Smith, what says the state?
Your Honor, I'll defer to the court on this.
All right, Mr. Adler, I'm going to authorize his release to mom. It will be on the electronic monitor. Mr. Elliott, you will be required to cooperate and you've been level 1-0 in the back for a little while. So that first, congratulations on doing that. That's awesome. Second thing is I expect you to maintain level 1-0 for your mom at home. If she tells you you have to go to the doctor, then you have to go to the doctor. If she tells you you have to take your medicine at this time, you have to take your medicine. Will you do those two things for me?
I got you.
All right. And third thing, don't cut off your monitor, right?
I'm not really. I don't do that type of things. I learned my lesson in here.
What happens if you cut off your monitor?
I come back and I have to pay a fine for the monitor.
Yeah. All right, we're good to go. Thank you, Mr. Adler.
Thank you so much, Judge. Appreciate it.
Thank you all for coming.
Thank you.
Okay, Chloe Payne-Ezel.
Morning, Judge Porter. I'm covering for Ms. Hicks, who's in training today.
Oh, thank you, Mr. Davidson. Good to see you.
Yes, sir. Good to see you as well.
Give me just a second. Already got that release. There you go. Okay, thank you. All right, Mr. Davidson. What brings the respondent? Oh, well, first, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney. And let me get Ms. Abels here in the room for just a second. She's working her way in. And let her get connected on audio. Good morning, Ms. Abels.
Good morning, Judge.
We are here in Chloe Payne-Ezel. And Chloe, do you see Ms. Abels on the screen?
Yes, sir.
All right. I told her she has the right to remain silent and the right to attorney, that you're her attorney. All right. So, Mr. Davidson, what brings Chloe to court today?
Hey, Judge Porter. Chloe has been with our unit for some time. She was actually placed on probation back in July of 2018 on a 2-year probation term for aggravated sexual assault of a child. She went to placement and spent time in placement at the center, the High Plains Youth Center, from 3/4/19 to 9/4/2020. At that time, she was reassigned to our units and placed back on community supervision. She has engaged services with our new provider, Lakeisha Washington. Since her release, she's had numerous violations that became a concern that resulted in an administrative hearing. The violations including sneaking out without permission, roaming in the community without supervision, putting herself out on social media as a 19-year-old female when she's 13. She also took a polygraph, which she cleared, but made numerous admissions during the polygraph, including some sexual contact with, I think, a 21-year-old male was one of the things that she admitted to. She also had been taking cell phones without permission, viewing pornography and different things like that, which resulted in us doing an out of custody hearing. And this is all since she's been released from placement in September. So we do have a psychological that's been scheduled that today we found out and we're given notice that that's been delayed and put off another couple of weeks. I think the 4th of January, coming back on the 11th. And the community plan at this time is not something we have on the table. We really want to get a look with an updated psychosexual evaluation, staff the case, possible placement search, things like that to see if there are other options, because we do believe she's putting herself in danger in the community and is high risk to be exploited while she's out and about unsupervised.
She has a parent or guardian here today, correct?
That's her mother, yes, Tricia Grimaldo.
All right, Ms. Abels, what are your thoughts?
Zoe, I mean, Chloe and I know there's nowhere for her to go right now. We've agreed to a placement search. And so I think that, and I think Chloe believes that that's what's in her best interest too. Being with her mom, her grandmother is not, I don't think secure enough. So I don't think you have an option but to detain her.
Mom, you heard what Ms. Abels just said.
I do. I agree that I think right now this is the safest place for Chloe and for the rest of the family. I do agree with that.
Mom, thank you for being brave enough to put the safety of your daughter at the forefront. That's a really, really hard decision to make as a parent.
Yes.
And I just want you to know I appreciate the strength that you're showing in making that decision. And I understand how hard it is.
Yeah.
Chloe, you understand what we're doing here today is to help you out, right?
Yes, sir.
We're not trying to punish you. We're trying to help you get to where you need to be the best responsible adult you can be and become, right?
Yes, sir.
All right. Based on the evidence before the court, I'm going to order that you be detained today. I believe that if I were to release you, you'd be a danger to yourself. And that'll be the order of the court. Thank you.
Yes, thank you, Judge.
Mom.
Thanks, Chloe. You bet.
Judge Porter, are you on board with a placement search for this young lady?
Yes, please begin that.
Okay, thank you very much.
Martin Nicholas Herrera. Martin, you're back. My name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is a 10-day hearing for you. Actually, we're doing it a little bit ahead of the official 10 days. You have the right to remain silent. You also have the right to an attorney, and your attorney, Ms. McGonigal, is here. All right. Ms. Thomas.
Yes, Your Honor.
Why is Martin back? He promised me the last time I saw him, it would be the last time I would ever see him.
He did. He actually left his mom's home on Saturday, December 5th, sometime earlier that morning, and did not return until Sunday. He also has, he was on the EM at the time, and we also have a removal that occurred sometime Sunday morning on 12/6 at approximately 1:51 a.m.
So he ran and then cut it off midstream while he was out?
Yes.
Okay. Ms. McGonigal, what are your thoughts?
Your Honor, I would ask that Martin be released today. He is on level 1, which is a significant achievement for him. As you remember, the last time he was in detention, we never saw level 1, and he's been on there for at least a week. So we'd ask that he be allowed to go home. Since he's been in detention, he has missed his his FPP assessment and intake, which was court ordered back in November by your.
Artie, go ahead and lay out your bingo in the chat, and I will take consensus and see if we've got a full bingo here. I do not believe we have heard wrong crowd yet, though.
So, excuse me, there's planes going overhead. So we would like that he be allowed to be released today and get that scheduled up. I understand that we just had court fairly recently, but you gave him quite a number of conditions that he really hadn't had a chance to achieve. So we would ask that he be back on the monitor today and restart that 90 days that you gave him as a condition back in November.
Martin, you're killing me. You're
Can I
killing
say,
me.
can I say something, Your Honor?
No. If you want to ask me a question, you can ask me a question. But if you just want to make a statement, I don't think Ms. McGonigal wants you to make a statement because the
I
DA
do not, Your Honor.
The DA's listening, and any statement you make might help the DA find ammunition to use against you. And you don't want to give the DA ammo, do you? So do you have a question for me?
No, Your Honor.
All right. Martin, what do I have to do? I got to order that you be detained. You cut off your monitor, and you didn't make it 2 months on me. So, but the fact that you're level 1, you're not level 1 outstanding, but you're level 1 is a great accomplishment for you. Ms. McGonigal is absolutely right. However, right now, I'm not convinced that if I were to release you, you'd keep that electronic monitor on. Here's how you convince me. You maintain level 101 for me and get from 1 acceptable to 1 outstanding, and then you maintain that 1 outstanding for me, okay? You do that, and it'll give me a good reason to believe that you might obey the conditions of your probation, okay?
Sure.
All right, that'll be the order of the court. Thank you, Ms. McGonigal.
Thank you, Judge.
Thank you.
All right. Jaden Michael Thomas Saylor. Why is this why do I have?
No, Your Honor, we were advised he was in mediation.
Saylor is in mediation?
Yes, sir.
Okay. Okay. Then we'll hold off on Saylor.
And then also, Your Honor, Wesley Smith is on the docket. He's in the middle of his psychological assessment. We were advised to leave him in there.
Yes.
Okay.
And we will revisit Wesley as soon as he gets that psych done. Let me know.
Judge,
Yes, ma'am.
can you just detain him?
Okay.
He's level 3 unacceptable. His parents found that out and decided to go to work today. Wesley seems to be not wanting to help himself as much as Mr. Reyes, myself, and his parents are. So if you could just detain him, we would save the court a lot of time.
Yes, ma'am.
Thank you, Judge. May I be excused?
Yes, ma'am.
Thank you, thank you, Jose.
Thank you, Mr. Reyes.
Judge Porter.
Yes, sir.
On Mr. Saylor, did you say you were going to revisit this issue later, as in later this detention hearing or a later date?
Probably later today, depending on the outcome of that mediation. Unless you, because we've either got to have a detention hearing today or tomorrow.
Okay. I mean, obviously I want him to do mediation. I just want to know if you want me to stay on the call or not.
Let's see. I'm looking. Is the probate? Who's here from probation on Jaden Saylor?
Your Honor, that one is currently assigned to Shannon Kelly. I don't believe she's online right now. What can we do to help the court?
If somebody will call Dwayne Houston to let him know when the mediation is over and let him know the outcome of that mediation.
Yes, sir. Okay.
And then Dwayne, you can just get back with me.
Yes, sir.
I'm going to be here for lunch, so whatever y'all need, I'll be here until probably about 2:15.
All right. Thank you.
All right. Thank you. go. All right. Nevia Tennyson. Is Miss Tennyson here?
I don't see her, Your Honor. Oh,
There
there
we
she is.
go. Are you Miss Tennyson?
Yes, sir.
Miss Tennyson, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney. And your attorney, Ms. Hamrick, is here. Do you see her on the screen?
You see me?
All
I'm
right.
waving to you. Hey, miss.
All right. Ms. Thomas, what brings Ms. Tennyson into court today?
Your Honor, Nevaeh left home without permission on Tuesday, December 1st, 2020 at around 1 p.m. She left in a car. From other reports, she came home in a few days prior and had been driving it, although she does not have a driver's license. She did not return home until the next morning, December 2nd at 2:30 a.m. She does have history with this department, Your Honor. On August 11th, 2020, she was adjudicated delinquent for theft of property and placed on probation for 9 months.
And her level in the back is what?
3, unacceptable.
All right. Ms. Hamrick, what are your thoughts?
I've had some discussions with her, and she has a psychological scheduled for the 21st, and I've asked that she be very cooperative with that since she's in detention right now. I have discussed with her need to be evaluated and follow any mental health guidelines, because the behaviors that she's exhibiting out in the community, including posting things online with guns and then possibly ripping people off, her behavior is very risky right now. And I have talked to her about my concerns that if any of these allegations are true and she's been doing any of this, she's placing herself at significant risk out in the community. So I've let her know that I'm completely think she's safer being detained than being released at this point in time.
Right. Ms. Tennyson, your level is 3 in the back. Before I can consider you for release, I need you to be at level 1 outstanding. Have they talked to you about the behavioral levels?
Yes, sir.
Okay. Give me 2 things that you can do between now and next week when you meet the psychiatrist. 2 things you can do to help improve your behavioral level in the back.
Stop talking to other people.
And
Stop talking big.
okay. Are you willing to do those 2 things to help improve your behavioral level?
Yes, sir.
Okay. We'll meet again. Either you and I will meet again, or you and Judge Terry will meet again. Between now and then, I want you to work on your behavioral level, okay? All right, but for today, I've got to order that you be detained. Thank you, ma'am.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Ms. Hamrick. Corian Titus. That is a cool name. Almost like Romanesque. It's like a strong name. That's a cool name. All right, are you Mr. Titus?
Yes, sir.
Mr. Titus, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Ms. Taylor, is here. Do you see Ms. Taylor on the screen?
Yes, sir.
All right. Ms. Blair, what brings Mr. Titus to court today?
Your Honor, he's a 16-year-old male who was brought in for murder and unlawful carrying a weapon. Per the report on December 2nd, around 7:30 p.m., police pulled over a vehicle while conducting a traffic stop. Police could smell burning marijuana emitting from the vehicle, and all occupants were removed. Police then searched the vehicle behind the front passenger seat where DeCorian was sitting. Police located a backpack and contained 2 firearms. There were no information on the weapons. Police also determined that DeCorian had a warrant out for murder. For the murder case on September 12th, 2020, around 5:15 p.m., police responded to a shooting call. They arrived at the location, victim who had been shot. He was transported to JPS where he was pronounced deceased. A neighbor, which was also a witness, gave police a description of the suspect's vehicle. Police also located several 9mm casings in the streets. Witnesses also reported that a vehicle had been driving by the victim's house, fired several shots which struck the victim and fled. Police reviewed their real-time crime center camera and located the vehicle entering the Buttercup Apartments. Police spoke with the owner of the vehicle and her boyfriend, Trevon Davis. At that time, Mr. Davis denied being in the vehicle. On October 28th, Ms. Atkins told police that Mr. Davis did use her car on the day of the shooting. On November 12th, 2020, police spoke with Maya Stewart. She reported that on the day of the shooting, she drove by and observed her boyfriend, Tommy Teray, in the backseat of the suspect's car. She also observed Trevon Davis during the vehicle and DeCorian in front of the passenger seat. This information was also caught on RTCC. She told police that Teray told her that he and DeCorian had shot the victim. On November 13th, police arrested Mr. Davis. He told police that he had picked up DeCorian and Mr. Teray. He drove them by the victim's house twice. The first time Teray fired shots and second time DeCorian fired shots. All are members of the Blood Gang. He did test positive for THC, and a petition has not been filed on the charges yet.
He is level 1 in the back, is that correct?
Yes, he's been on level 1 since he's been here.
All right. Ms. Taylor, what are your thoughts?
Judge, I understand that this is a very serious charge. However, no petition has been filed. And from the summary, sounds like a lot of uncorroborated co-defendant testimony is going to be involved in this matter. DeCorian has no history with this, he has supervisory caution, but he's 16 years old. First referral, I know it's a serious one, but he really does want to go home. He's got a courtroom full of people there to show their support for him. He's got a strong support network. And I believe with an ankle monitor, we could ensure the safety of the public at the same time allowing this young man to be back with his family.
Ms. Blair, Ms. Taylor just mentioned that he has a history of supervisory caution. What was that for?
Your Honor, it's for evading arrest detention. It happened back in August 10th of 2017.
Okay, so 3 years ago.
Yes.
All right, Ms. Smith, what are your thoughts?
Your Honor, this is the most serious charge that one can have. I would ask that he be detained for the safety of the public and due to this charge.
Judge, if I may point out further, the PACT assessment indicates low risk, low need. This charge allegedly occurred in September. And he's been out in the community after this charge allegedly occurred with no, I certainly understand Ms. Smith's position and I agree with her. It is the most serious charge that a person can have, but nothing's been filed at this point. He is not with a low risk, low needs assessment on the PACT and his behavior back in the detention facility, there's no reason to believe that he wouldn't continue level 1 out in the community.
Right.
Your Honor, may I respond to that briefly? I understand that this did happen back in September. It wasn't referred to our office until December. However, he was caught because he was caught with a weapon in his car with the smell of marijuana emanating from it. So I wouldn't say that he's been perfectly fine or level 1-0 out in the community. In fact, he's been the opposite with another weapons charge.
All right, last rebuttal, Ms. Taylor.
I don't believe it was his car, and thus far we haven't seen any evidence that it was his weapon.
He was a mere victim of his own bad choices of friends, right, Ms. Taylor?
That's exactly right, Judge. And
All
he
right.
will make the same mistake again. I've basically explained I've explained it's very unlikely that he'll be released today based on the nature of the charge. If he is released, he understands he will basically be on house arrest. And he's prepared to do that. I've also explained how dangerous it would be for him to get out and pick up any more trouble. He's ready to do what this court asked him to do. And I think he's demonstrated that he has the ability and the willingness to do that.
Ms. Taylor, you have made many, many excellent points. A murder charge just really scares me. And it's not just any murder charge, but the circumstances surrounding it, that one or two people may have been working together, multiple shots fired. You know, I've worked on these cases as an attorney before, and the last one that I worked on that was very similar. The kid, and he was an 18-year-old kid, or he was actually he just turned 21 3 days before that happened. He ended up getting the death penalty, and that just scares me. I don't want that for you. And so based on the circumstances of this offense, it's just too scary for me. I can't authorize your release today. All right, that'll be the order of the court.
I love y'all, Mom.
You too, boy.
All right, finally. Judge Kim, would you like to do the last detention hearing?
He's a special guest.
Oh, okay. Ladies and gentlemen, we have a judge today who has a little bit of familiarity with this last case. So I will pass the baton.
Thank you, Judge
Porter. Good morning, Judge Kim.
Good morning, Ms. Reyes. All right. Do we have a parent here for Mr. Valley?
Yes, Your Honor, we have Mom here.
Oh, hello, Mom. All right. So, Rudy, I'm Judge Kim. This is a detention hearing. When a kid's brought to our facility, you have to see a judge within 2 days. I have to decide whether to keep you or release you. If I keep you here, you have to see a judge every 10 days while you're here. You do have a right to remain silent, and you have a right to an attorney. Your attorney is, I don't know, Ms. Taylor, no?
Yes, Judge, I believe Mr. Green is his attorney of record, but he's unavailable, and so I've been asked to cover this.
Okay, well, thank you, Ms. Taylor. All right, so Rudy, you were set for court for a disposition hearing, I believe, and you didn't appear to court. You were out on electronic monitor November 30th. There's a temporary electronic monitor, and we issued a warrant for you. Definitely, you had stolen your sister's car on 8/20 when you left the house. And this is while we let you out, while you have a pending case for robbery and engaging in organized crime and theft. We'd probably let you out to see how you would do to decide whether you get probation or not. All right. Now, my question for you, Ms. Taylor, it's not a question related to the offense, but I'm curious. I see your mom here, Rudy. Like, how much do you love your mom? How important is your mom to you, Rudy? You just not want to say anything at all? Is the microphone not working?
It's working.
Okay. Is he just refusing to talk? Security control, are you there?
Yes, he knows he's not responding, sir.
Oh, he's not responding. Okay. Well, Mom, does he do this to you? Does he act like throw a temper tantrum like this with you?
Yeah.
Doesn't surprise me. So, you know, a 4-year-old's gonna 4-year-old, right?
Yeah.
So one thing, Rudy, is and it's also come to my attention that you were posting a video on Instagram, firing guns in the air, saying that on my mama, I'm gonna pop an HB. So I'm concerned if I was to let you out, you're gonna go ahead and shoot a kid. And so I think you're an absolute danger to yourself and the community. I think you're not gonna return to court when it's time to return to court. And so I'm gonna go ahead and detain you. I think Stephanie is listening. We'll go ahead and if you can make an order, Stephanie, that this child's not to be released specifically without the district judge's permission. All right, Mom, sorry about this.
No, he needs to stay in.
Yeah. And there's no question about whether you love your child or not, whether you want the best or not. He's going to do what he wants to do. And so.
Your Honor, I may.
Yes, Ms. Reyes.
He also picked up, he's gonna be ending two more offenses 2 days ago from, I believe, that's Burdensome PD. Johnson County. They're gonna be filing a police report on a firearm theft and a cell phone as well.
Okay.
2 more charges coming up.
Oh, another felony offense, maybe 2 felony offenses.
Yes, Your Honor.
Well, Mom,
And
this
at
is
this
not where
point,
you.
I spoke to the detective McClure this morning, and he's still wondering where the gun is, and he was asking me if I had the opportunity to ask Rudy where the gun is.
Well, he has an attorney, so you'll have to ask Mr. Green if he wants to. Yeah, if you have permission to ask him, but otherwise, yeah, you can't ask on the behalf of the police.
Correct.
So, all right. Well, Rudy, 15 years old. I'm sure this is not where you expect to be at this point, but decisions have consequences. So, Mom, do you have any
Judge Kim?
questions?
Yes. So I think a couple of months ago, you ordered placement. I don't know how it fell through the cracks, what happened. He's been released twice since then, and he's just going to continue to do this. And I know I'm going to get a call. Either he's killed someone or he's dead himself. I think placement is, or TJJD, that's the only options for him.
Sure. Mr. Reyes, how is that placement search going?
Your Honor, he was still pending. We were gonna resolve that when we're supposed to go to court the 12th, on the 8th.
Yeah.
But nothing happened.
Okay. I'm not really interested in the placement search anymore. So not when he absconds. That's off the EM.
My understanding, Your Honor, was that they'll decline. They're not willing to take him.
Sure. I understand. Okay. Well, yeah, if they've already made that decision, they've made that decision. Are we, Mr. Reyes, are we looking at any, I guess, I don't know if we're looking at determinate sentence cases or just.
Probably, Your Honor.
I guess the robbery, I think it involved a gun according to these notes. Is that determinate sentence approved, or Ms. Smith, do you know if it's been submitted yet to grand jury? Do you intend to submit it?
No, Your Honor, the only thing that I have pending is the ag robbery, the organized crime, engaging to organized crime, the theft of the cell phone, and the 2 more coming up.
Okay, so we do have an aggravated robbery.
Yes, Your Honor.
Okay. Ms. Smith, do you have any notes saying that y'all are going to seek determinate grand jury approval?
I don't, but I'll get with Alex. I think this is his case and see if he plans on doing that. The only issue with that at this point is that if it is not sought, the grand jury, I think tomorrow is their last day in session, and we are not clear when we're getting another grand jury. So that may be an issue.
And I almost missed one more, Your Honor. He also has pending he ended up taking his sister's vehicle. That's another actually motor vehicle.
Okay, that's not determined sentence eligible. Okay, well, I guess decisions have to be made. All right, thank you, Ms. Smith, Mr. Reyes, Mom.
Thank you.
Rudy, Merry Christmas to you.
Thank
All
you,
right, thank you,
Honor.
everyone. I conclude detention docket for today.
Thank you, sir. Good day.
Don't worry, guys. We're starting again. It looks like we got what's his face back. God, what is his name? Rudy? No, that was who we just had.
Yeah, one after the other. Or
Coach B, we'll come to detention hearing. We'll do everything all together.
combine.
Yeah.
Rodney, yes, thank you.
All right, thank you.
Judge, is the volume on? Is the audio on?
Yes, it is.
All right, thank you.
All right, are we ready to proceed?
Yes, Your Honor. Case ready, Your Honor.
Okay. Thank you.
Sorry, y'all. That's not what I thought it was. We're on to the next one. Sorry. That was a full Rodney hearing. I'm not in for that. I'm sorry, but no.
All right, this is the detention docket for the 323rd District Court. Thank you, Mr. Warren. On December 21st, 2020, just detention, you're back there. Just let you know, Ms. Morano's attorney just brought in a waiver, and so he will not be needed. He's on first today. All right, so this is the detention docket. In order to comply with the Texas Supreme Court Emergency Order number 30, we are not conducting in-person proceedings. However, we are using Zoom, the remote software. In order to comply with the Texas Open Courts Act, we are broadcasting these proceedings online on YouTube for the public to observe what is occurring inside a public courtroom. No, this is still a court setting though, so no portion of this, first of all, no portion of this recording or this hearing may be recorded, copied, or published. Violations are punishable by contempt of court of up to $500 to 6 months in the Tarrant County Jail. And since this is a court proceeding, the court does expect everyone to have their cameras on unless you're an officer of the court and to behave appropriately. So please do not be in the restroom, laying in bed, in your pajamas. No blinking Christmas lights or bright lights behind you that cast out your face. Don't be going for a walk or your jog around the river path and these are all things that happen. Oh, domesticated animals. Please refrain from having domesticated animals walk across the screen. So at this point, Ms. Christy Spencer, Ms. Brandy Gilbert, Ms. Audra Singleton, Ms. Laura, Connie Brunson, all your cameras need to be on. If not, I will remove you from the court proceeding. All right, so we'll go and start with Alan Brazzaville-Vazo.
Right here, Judge.
Okay, Christy Spencer and Connie Brunson, this is your second request to turn on your cameras. All right, so you're Alan?
Sir.
Are you Alan?
Sir.
Okay. Do we have a parent here for Alan?
Yes, Your Honor.
Okay, she's in the room. All right, so Alan, I'm Judge Kim. This is a detention hearing. When a kid, you've been here for 10 days, so I'm reviewing your case, decide whether to keep you here, release you if I keep you here. You see a judge every 10 days while you're here. You have a right to remain silent. You have a right to an attorney. Let's see.
Present, Your Honor.
We're brought in for assault with a deadly weapon. There's a shooting call. Somebody shot in the chest. Oh, this is over the music with a neighbor. Yes, Mr. Brazzaville-Vazo. I am concerned about children having guns. I am not comfortable releasing you. I'm glad you're level 1 outstanding, but I'm not ready yet. Sir, sit down. All right, actually, just let him go. Put a note in there, do not release them. DK will not go. No, you just done it. So I'm just not interested in you. So at this point, I've just put down, since you stood up in the middle of me talking, that you're not to be released without the district judge's approval.
You already told me that last time.
For me to do that, to decide. So you can go. Merry Christmas, sir. Spencer Gilbert.
Fuck you too.
All right, now you got to bring him back. All right, so what is that you said?
Say fuck you too.
That's what I thought you said. All right, Mr. Gilbert, so is there any reason why I should not find you in contempt for using profanities at the court at this moment?
Yes, Your Honor, I'd argue on his behalf that he's a young man. He's under a lot of stress. He was told once if he was on level 1, he would be considered to be released. And it's going to be a long time before we could try this case.
Okay, do you have any mitigating evidence on what the court should consider in determining what his punishment should be for the contempt of court?
Your Honor, I would argue to him because of his age. He's a young man. He hasn't got through high school yet. Yet again, he's under a lot of stress and does want to be released because he believes he's innocent of the felonies charged with.
Okay. So he is 16 and 4 months. All right.
And Your Honor, I'd request that you put off any hearing on contempt until after his charges are disposed, as those could prejudice his sentence in the underlying cases.
I will grant that request, Mr. Green. The court will take that under advisement. and deal with the contempt at a later date. All right. Well, I tucked it away in the file box up here, right? So, all right. Well, just so you know, Mr. Let's say Allen, decisions have consequences. So, all right, we'll see you in 10 days. All right, we'll deal with Mr. Spencer Gilbert.
Maybe excuse, Judge.
Yes, thank you, Mr. Green. Merry Christmas, or, well, you don't observe Christmas. Happy
Thank you,
holidays.
sir. I appreciate it.
Happy
Bye.
winter solstice, I think, right?
Thank you, sir. Bye.
Mr. Gladstone.
One of those holidays.
I try to be cognizant. I wish you a happy Hanukkah.
Yeah, I did remember. Thank you, Judge. Merry Christmas to you. We don't meet each other before then.
All right. We have Mr. Gilbert here.
Yes, sir.
All right. Hello, Mr. Gilbert. I'm Judge Kim. This is a detention hearing. The law says when a child's been brought to our facility, you have to see a judge within 2 days. I have to decide whether to keep you or release you. If I keep you here, you can see a judge every 10 days while you're here. You have the right to remain silent. You have a right to an attorney. Your attorney is Mr. Gladstone. All right. So, Spencer, 17 years old. So we issued a warrant for you on December 10th. We got an email from Johnson County saying you got in trouble at home for a cell phone incident at school and not doing your schoolwork. Sister gave you the keys so you could sit in the car and calm down. They realized that you took the car and the car was gone. They've allowed you to drive around the neighborhood before, but you weren't in the neighborhood. So, see, a couple days ago, Mom said that they recovered the car, they had the car, you're still on the run. You sent a text saying that you drove the car to Fort Worth and abandoned it, and she had to get the car back from it, pay an impound fee. And they dropped the UUMV case. All right. Give you a drug test, you're negative. All right, so, Mr. Gilbert, hopefully this is just a poor decision it's a one-off, in that this isn't who you really are, and you just made a bad choice. But when the courts had to get involved and go ahead and issue a warrant, and the police had to go pick you up and bring you back here, I'm going to go ahead and detain you. We'll see what your behavior level's like. We'll decide whether we're going to release you or not after that. I'll let you know if your behavior level drops since you're 17 years old. I can send you to the adult jail in downtown Fort Worth. So I encourage you to make sure your behavior level is a 1-0. That's the one way you can guarantee that you're going to stay here. If your behavior level drops a 2, I'm going to send you downtown. If it's somewhere in between, it just depends. All right. So you know, did you have a question for me, or did you want to tell me something?
Yes, sir. Yes,
okay.
Sir.
What's your question?
When they picked me up, I was on a list as a runaway, and I was with my mom at the time.
Is that it? So what's your question?
So how was I listed? How did I have a warrant if I would talk to my PO on Friday? I had just
because once the warrant's issued, then you have to come back to the court to lift the warrant. Just because you talk to the PO doesn't mean it automatically gets lifted, right? You're under supervision. We expect you to be accessible. If you're not, then we issue a warrant and you have to come back here.
Okay, so how long am I supposed to be staying here?
Well, that's really up to you. If you misbehave, you're not going to stay here for very long at all. You'll go downtown jail. If you behave, you'll stay here for a little bit longer, and we'll decide whether to release you or not. But it's going to be at least 10 days.
I really want to go home for Christmas, though.
Well, I'm sure you do, but I really wanted you to stay at home before Christmas, and you didn't. You ran off.
But I was just upset at the point. I was upset at the moment. I wanted to be away for a second. I didn't want to do nothing
at a certain
stupid.
point, you thought it was worth it to drive off to Fort Worth and abandon the car. And you said, if there's a consequence from the court, it's worth it to do this. And so.
No, it wasn't like that, Judge Kim. It wasn't like that at all. It was that I didn't want to risk doing nothing else stupid.
So you're telling me I should reward you for only taking a car, running away, and ditching the car?
No, you shouldn't reward me for anything. But I wanted to leave so that way I wouldn't do anything stupid. So it wouldn't cause me to have to stay somewhere else. had to really go to the county.
I'm not going to congratulate you for not committing a felony. You're not supposed to commit a felony. Raise your expectations. You got to raise your expectations to match mine. I expect big things from you. If you make bad decisions, bad things are going to happen. All right. All right. Thank you, Mr. Gilbert. Nathaniel Nix.
Thank you, Judge.
Thank you, Mr. Gladstone. Oh, that was a very novel argument.
Judge, there's no parent present.
All right, thank you.
For this young man. She's gonna be at work till 1:30.
I understand. All right, Mr. Nix, I'm Judge Kim. This is a detention hearing. It's attorney requested detention hearing. All right, so you're 16, you're almost 17 years old. You've been here for 8 days and you're level 1 outstanding. So, Ms. Herrick, are you here? Ms. Herrick's not here. Okay, let's put her back to the list at the end of this and we'll get back to Mr. Nix. Ethan Nordyke. It's out of custody detention hearing. Mr. Nix, just hold on. We're waiting for your attorney. I'll be honest, that argument that kid made is kind of the argument I expected Richard Gladstone to make. It's kind of appropriate.
I've actually made that argument.
And Miss Abels, you would not let me down either.
I've made it.
Did it work for you, Miss Abels?
No, sir. I wanted to tell him to stop. That didn't work. I've tried.
Okay. All right, Mr. Nordyke, I'm Judge Kim. This is a detention hearing. My decision now is to take you into custody or to keep you in the community. If I take you into custody, you see a judge every 10 days while you're here. You have the right to remain silent. You have a right to an attorney. Your attorney, Mr. Willett, I believe is here. I think I saw. There we go.
Judge, that's me. I'm sorry. Ethan Nordyke?
Yes.
That's me. I'm sorry, Your Honor. I don't know if Mary told you.
Oh, you got retained on this?
No, Ethan was, it's kind of a long story. I don't know if you have time, but I'm going to be his attorney. I've represented him twice and already talked to the granny. I don't know if Brian has or not.
No, I didn't. I just
All right, so
sorry, Brian.
Okay.
Brian, we'll roll you to the top of the list so you get the next one.
Okay.
All right, thank you. Is this your only one, Mr. Willett?
Yes.
Okay, have a Merry Christmas.
Sorry, Brian.
You too. Thanks.
Yeah, if you can put Brian to the top of the list so he gets the next appointment. All right, so let's see, Ethan.
Yes, sir.
10 days ago, we got a referral for out of custody referral for ag robbery and ag assault. According to the police report, police were dispatched to Janetta and Cummings for a victim about getting robbed. So he was walking Janetta. He was approached by an unidentified suspect. They flashed a handgun, demanded the wallet. Victim said the suspect stole his wallet and cell phone and hit him in the face with a handgun. Well, Ms. Hall, how does he link to this one? Oh no, I'm sorry. That was a report from November 12th.
Judge, I'm covering for Joy Hall. She's out this week.
Okay.
The DA actually asked us to go ahead and bring him forth to you because of this offense where he was accused of robbing 3 victims with a handgun.
That's November 12th, isn't it? November 13th, North Hills, there's a student said got robbed. Student who's now victim 2 said driven to victim 1 to sell weed. Victim 1 was selling weed, robbed him at gunpoint. Drove from Grayson Ridge to Parkwind. They got there at 6 o'clock. Suspect opened the rear door, displayed a gun, racked the slide, demanded all the stuff. When they said they didn't have anything, he struck him in the head. Pictures of the injury. right, Ms. Campos, so far I don't see anything that actually identifies Ethan here.
Judge, if I can jump in there.
No, you can't. You can't. I mean, by statute, it's not adversarial.
If I can point the judge to the port in the parts of the offense report that.
Okay, sure.
Yeah, if you look at the November 14th portion that talks about the detective,
okay.
One point says that a witness they interviewed said that Ethan said he intended to rob the seller of the marijuana. They found a phone, the stolen phone, which had his fingerprint on it. And then if you look towards the end, right before it says offense history, 2 paragraphs up, the photo lineup, victim 1 identified Ethan, though wasn't 100% sure.
Okay.
Are kind of the highlights.
Okay. Some reports, crime scene said they got the fingerprints from the victim's cellular phone and compared it to Ethan's fingerprints, and they were confirmed. Okay. All right, so this. All right. And Ms. Campos, his probation's expired for the robbery?
No, I don't believe so.
He said he got probation August 15th, 2019. Oh no, so he's on probation now. He got picked up for an aggravated robbery?
Yes.
That's why the name's familiar. Right. Okay, well, at this point, Ethan, so this is the first time, this is out of custody referral for the aggravated robbery, correct?
Yes.
Okay, all right, Ethan. So you understand my feeling about kids with guns. I have a big problem with that, and that I detain them. And the fact that you're on probation right now gives me great concern. Before we give you a drug test, anything you want to come clean with?
I'm positive THC, but that was like 2 weeks ago. But...
All right, yeah. So, I mean, it'll show up in the drug test. So I'm glad you told me. I'm glad you're being more honest and forthcoming. So, Mom, I hope you understand that, I mean, this is not acceptable behavior. So we're going to take you in custody. We'll see you in 10 days. I'm going to let you know, Mr. Nordyke, you shouldn't get your hopes up by getting out in 10 days if you're level 1-0, because it involves a gun. I take this very seriously. I go very cautiously whenever kids have guns, okay?
Mr. Judge, can I please speak?
Well, if you want to ask me a question, go ahead. If you want to tell me something, I know your attorney does not want you to tell me a story, okay?
No.
So do you have a question for me?
I have a question.
Yes, I'm happy to answer a question.
Do you think you please put me on the monitor so I can keep my job? And so I think my girlfriend may be pregnant and I just want to stay out with her.
No, sir. So when kids have guns, that's just the greatest concern for me. It's not just let you go and hope for the best. I've got to be extra careful. We just adjudicated a child for murder this morning, before this hearing. All right, kids with guns really ends up with really bad situations, bad consequences. All right, this is just good decisions have good decisions come from experience. Experience comes from bad decisions. I hope this is an experience. If you did it, I mean, there's still the presumption that you didn't do it. All right. Thank you, Mr. Nordyke. Jordan Saunders.
Thank you, Judge.
Thank you, Mr. Adler. All right, Ms. Taylor.
Good morning, Judge.
Good morning. All right, so Jordan, this is a attorney requested detention hearing. If I keep you here, you'll see a judge every 10 days while you're here. You have the right to remain silent. You have a right to an attorney. Ms. Taylor is your attorney. Ms. Taylor, for what purpose did you request this?
My client asked me to request a detention hearing because Christmas is coming up and he understandably would like to go home. Moreover, he had a detention hearing a week ago, I believe, and Judge Porter, and at the previous, when he was previously detained, I believe he's been level 1 outstanding. Judge Porter indicated that he was very happy with his behavior in the detention facility, but he just wasn't comfortable yet releasing him. It's my understanding Jordan's maintained that behavior and he wanted me to try to get in before the court closes for Christmas and asked to be released on a monitor. I've had a lot of conversations with him.
Sure. So Jordan, just so you know, Christmas itself means nothing to me as far as detention hearings. All right. Just because it's Christmas, I'm not sentimental about that. I'm just going to look at it like it was any other day. So you're on probation for theft. That was from November. Wait, he just got on probation?
That's correct, Judge.
And then 5 days after he's on probation, he was caught breaking into a house.
Oh, no. I think the allegations are Nothing's been filed yet, other than the count 4 has been added into text share for the violation of a court order, violation of probation. He was, without going into too much detail, it was late at night. I've already addressed with his parents why he would have been out at that hour, and I've received it.
Hold on a second. So he got placed on probation November 20th. On November 25th, he was referred by Mansfield, saying that about 3 o'clock in the morning, they were dispatched a suspicious person call on the Ring doorbell. They ran off. They patrolled the area, found 2 people inside. When the police got there, the 2
inside
people
a vehicle.
I'm sorry?
Inside a vehicle, Judge.
Inside a vehicle. Then they fled on foot and were apprehended. And let's see, they found stolen items inside the car and work tablets, purse. They forgot to lock it. Okay, so the owner of the car said they forgot to lock it. Yeah, I missed it. All right, Jordan. So less than a week that you're placed on probation, that you're caught 3 o'clock in the morning in a car with a bunch of stolen goods. And so if I release you, you're just going to break into more cars or be part of other people breaking into cars. So I'm not going to release you. I mean, people deserve to be able to keep their Christmas gifts that they're going to get. Yes, Mr. Saunders, you have a question for me or you want to tell me something?
I would like to say something, not a question.
You want to tell me something, your attorney does not want you to tell me something. If you have a question, I don't mind answering.
It's not about my case, sir.
Well, that's something you probably would bounce off your attorney because I don't want you to put yourself in a spot. Right?
It's good. It's good things. I was just gonna say that the last time that I was on a monitor that I did good, and I took the initiative trying to show you that I'm gonna do good by keeping a 1-0 here and continue doing good, sir.
Well, I mean, please do. I'm glad you're level 1 outstanding. But again, I do not look at Christmas as anything special for detention. It's another day. When kids, and part of the thing is, if you in fact were breaking into these cars on November 25th, 5 days after you're on probation, you should have realized that you were this close to Christmas, and you got caught, you would be spending Christmas at Kimbo. Right? So I'm just saying, I don't know if you actually did it or not. I don't know if you're involved or not. That's for your attorney to fight. What I see is 5 days after you get on probation for theft, you're caught in a car with stolen goods at 3 o'clock in the morning. So you did not take your probation. Like, probation means something.
But if I was on house arrest, how would I be able to rob people, sir?
Well, the monitor doesn't keep you from robbing people. It just tells us where you are when you rob people.
But I would be at the house, sir, since I'm on house arrest, sir.
But you weren't at the house. You were in a car on the streets at 3 o'clock in the morning.
But I wasn't on house arrest, Your Honor.
You had an order of probation that you were supposed to be at home.
Yes, Your Honor.
So, yeah, I mean, you weren't where you're supposed to be. Having the monitor wouldn't physically keep, it's not like it shocks you when he walks outside the house. Although, Kelly, we need to start ordering some of those, right? So, but yeah, no, you were free to leave, and you did. And so at the very least, you're outside the house in violation of your probation, right? So it's going to take me more time, but I'm not willing to release you. It was only it wasn't even a week that you were on probation before you were already outside the house. Ms. Taylor, I understand your client asked you for this hearing, so I don't blame you, but I hope you understand where I'm coming from.
I do, Judge. I appreciate your time and your consideration.
You're welcome. Merry Christmas, Ms. Taylor.
You too, Judge.
Right. Yes, ma'am. Jada Singleton.
Judge.
All right, thank you. All right, Ms. Singleton, I'm Judge Kim. This is a detention hearing. You have the right to remain silent. You have a right to an attorney. If you cannot afford one, we'll provide one for you. Ms. Abels is your attorney. All right, Ms. Abels, for what purpose did you request this detention hearing?
Judge, we had a detention hearing, I believe, last week. And at that time, Jada had a psychological scheduled for Wednesday of this week. And so Judge Porter asked us to reset the detention hearing on Wednesday after her psychological, whatever time that was. Well, they've moved her psychological to, I believe, December 30th. And her adjudication hearing was set for January 5th, and it got moved out farther as well. So Jada has an aunt. I believe it's an aunt that she can go live with who may be here today with her mother.
Yeah.
Is she
Yes,
here?
she is. Yes, Miss Laura is the aunt, Miss Laura Smith, and then mom is on as well.
Right. And I'd heard that the aunt was coming too. And so since they moved everything out farther, I thought that I would set the detention hearing that Judge Porter asked for last week.
Have we done the psychological?
It's not gonna, this is like the fourth time it's been scheduled.
Yeah.
And so one time she was STAR testing, another time they didn't show up. They reset it to this Wednesday. I don't know why it got reset until the 30th.
At this point, yeah, I'm sorry, Key. At this point, the female unit is quarantined, Your Honor. So it was originally set for the 23rd after the STAR testing had it to be reset. And so because the female unit is under quarantine, it was reset now for December 30th, which is when the unit will be out of quarantine.
So she is on probation for ag assault, deadly weapon. Is that correct?
Yes, and UUMB.
Who was the victim on that case?
Was it mom?
It was sister.
Sister, okay.
How old is the sister?
19.
19.
All right, so Ms. Judd, are you covering for Ms. Burns?
I am, Your Honor.
All right, well, I can put you on the spot. What's your recommendation?
I do have Miss Laura on, the aunt. I did speak with her. She is concerned about the quarantine status. She does live alone. However, her grandson will be visiting over the holidays, and with the quarantine status up on the 30th, which is the day of the psychological, I believe it would be best for her to remain in detention until that date where we can get it all done.
Yeah. So, Singleton, this is where I'm on the fence, right? I can go either way on this one for varying reasons. One, your behavioral health, I'm glad. Part of what working against you is we need to get the psychological, and you have a history of running away. I don't know if you'll come back for a psychological if we let you go. The plus side is, you're 17. I almost feel like you're almost an adult, and you have your own decisions to make. That's kind of makes me want to release you, but part of what makes me want to hold you back is the fact that that you have a history of running away with adults, and that makes me really uncomfortable. So it's just, there's a whole bunch of things that are counter competing on this one.
Judge, this is a case where she and her mom have issues.
And this is where that lady just showed up saying, I'll take her in.
No, yeah, it is, but this is an aunt that mom approved.
Right. But this is the case that
Yes,
that
sir.
lady.
Yes, sir. And Jada's been on level 1 outstanding since she's been here. Now, having said all that, I understand the COVID and quarantine issue. And Jada and I haven't talked about that because I didn't realize they were in quarantine until a certain day. And she couldn't come in our house right now. I can tell you that because we've all been exposed. Anyway, so Miss Laura, I believe Miss Laura really wants to take her. I believe Miss Laura will return her. But
I'm not worried about Miss Laura. I'm worried about Jada.
I'm not that worried about, I really am not that worried about Jada. And because she's run away, like, I'm just not that worried about that. But I've had multiple conversations with her that you haven't had. I believe Miss Laura would bring her back for everything she needs. But Jada, we got to do what Miss Laura says. Just like I told you yesterday, you got to do what Miss Laura says, and that starts now. And
But Miss Laura is the aunt, right?
Yes, and if Miss Laura is having company over Christmas, Miss Laura doesn't want somebody who's been exposed in her home. We have to respect that. We also have to respect what Judge Kim says, or act like we do. And so,
she has a point.
And so, really and truly, what those two say right now is what's going to matter. You're still level 1. You've still been level 1 the whole time. I think you've learned a great deal being in here. I think not going home to your mom.
Judge, how long has she been level 1? I don't show a date.
Since November 12th, Your Honor.
Oh. Stand down.
Jada,
Yes.
get level 1 back there. What happens if, I think I give you the pin sheet. What's a DNA back there, Jada? DNA back in detention. What does DNA mean?
Do not associate.
Right. So what happens if Miss Laura says, do not associate with this person?
Miss Laura,
Yes, Miss Laura.
I don't associate with that person.
Right. What does slow to comply mean back here? Failure to comply.
Can you repeat that?
What happens if you're slow to comply here at Kimbo? You lose points, right?
Yes.
Do you understand? You're level 1O back here. I'm expecting if I release you for you to be level 1O with Miss Laura, right?
Yes.
So if we get a phone call saying Jada's just not listening to us, she won't get up, she won't clean up, she won't do chores, what do you think I'm gonna do?
Put a warrant out.
Yeah, you gotta be level 1O if I send you home, okay?
Okay.
Miss Laura, are you here? She's just in the, there you go, Miss Laura.
Yeah.
Miss Laura, knowing that she's been in the quarantine pod, so there are interactions with certain children that are COVID positive, are you still wanting Jada, to come back with you?
Is she negative?
She is negative, but she could have been exposed. I mean, she has more or less been, she's living in close proximity to other people who are positive.
I'd rather that it be tested again and that it come out negative.
Well, it is negative. She has never tested positive, okay? But you have to understand, it's a detention facility, so there are detained children and adults that periodically test positive. There's no way to tell. So there's a 2-week incubation period. So we could test her today and she's negative, but that didn't mean in the last 2 weeks, if she came across somebody and became infected, then it wouldn't show up yet on the test.
Okay.
Do they ever get out of their rooms during quarantine?
They do, but they have to take showers individually, they eat in the cafeteria individually.
So they're never in a group during quarantine.
They're not in a group setting during quarantine.
Okay, then.
Are you okay with her coming with you?
We'll make it happen.
Okay, well, I will do that, Jada. So Jada, just so you understand, I'm not doing this because Judge Kim has a soft heart and it's Christmas time, right? I'm doing this because you did your part and you did the right thing by being level 1O for an extended period of time, right? And you're talking to me like you're actually going to be responsible grown up, okay? So you earned this one. This is not a gift this is not a Christmas gift from the judge. This is you earning it. Remember when I tell you good decisions come from experience, experience comes from bad decisions. And it looks like you're making some good decisions, all right? So I want you to take this and go forward. Any questions, Jada?
No.
Judge,
Your Honor.
Are you gonna let me down?
No, sir.
All right. Do you think I'm gonna bring you back here if you're causing problems?
Yes, sir.
You know I will, right? All right, thank you. Ms. Abels, were you saying something?
Yeah, Miss Laura is in charge of who Jada sees, where Jada goes, and all that, right?
Yeah, Jada, she's issuing the DNAs to you. She's like, you can't hang out with them, you can't hang out with them.
Okay.
I'm not, so that means that Audra Singleton, even though she's Jada's mom, right now she's not making those decisions. Is that right?
Ms. Laura's making those decisions. I'm releasing it to her. And the reason why, Jada, is because if you run off, I can put Miss Laura in jail until we can find you.
Don't do that to Miss
You
Laura.
understand that, Miss Laura? Like you're signing her out, so that means if she runs off, you're responsible, and I can issue a warrant for you until we find Jada.
Okay.
Are you willing to take this responsibility?
Okay.
You are willing to, you're going to sign a piece of paper just to make sure you understand that, right?
Right.
Okay. All right. Jada, this is your past decisions can come back and get you sometime. All right. All right. Thank you, Jada.
Your Honor, I'm sorry.
Yes.
I just want to clarify. Was that electronic monitor or no?
Yes, I've already signed the EM order.
Okay, thank you, sir.
Thank you, Ms. Judd.
Thank you, Judge.
Thank you, Ms. Abel. Jacqueline Spencer. I'm start thinking of a soft heart.
You do.
Attorney requested, yeah. Okay. All right, Mr. Spencer, I'm Judge Kim. This is a detention hearing. I'm deciding, you've been here for 10 days, so I'm reviewing your case. You're level outstanding. You have been for 3 days now. Let's see. You were not on probation. There's an ag assault. Police arrived, detained Jacqueline. He had some weed in his pocket. They were dispatched for a shooting. Guy was shot in the leg and hit his femoral artery. Your surgery. All right. Well, my first question, Ms. Turnerhill, why did he drop down from level 1? What happened?
Your Honor, he got into a fight in detention, and so he was a level 3, and so he's just working his way back up. But the fight was on December the 4th, and it's my understanding the victim wants to press charges. We just haven't received the police report yet from the Sheriff's Department.
Sure. All right, so Jacqueline, you're here on a gun charge. You understand that gives me great, great concern. But the fact that you're back here getting in fights and causing problems, I'm not ready to release you to the community. So I'm going to go ahead and detain you. We'll see you in 10 days. All right, so security control, Nathaniel Nix, the attorney requested this detention hearing, but we can't find her. So I'm going to put this aside. Judge Porter's going to take over the rest of the detention docket. If she shows up, we can have the hearing. If not, then we'll just see him at the regular scheduled 10-day.
Yes, sir.
So Judge Porter is going to take over the docket from here.
Thank you, Judge.
Thank you, Mr. Anigi.
He wants to fight me.
Miss Laura, you can go. Can Miss Laura go?
Okay, thank you.
But wait, you got to meet with Miss Judd, okay?
Okay,
Like, don't go home.
I'll call her. She's not here right now, Keith, so I'll call her.
Okay, then stay home. And no
Okay.
Thank you, Miss Laura. And hey, will you give Miss Laura my number? Okay, thank you. If you need something, you call me, okay? Because I'll come
Okay.
beat her up.
Okay.
I probably shouldn't say
All
that
right.
on Zoom, but that's all right.
Okay, thank you. Bye-bye.
Your Honor, I think this sounds a little messed up.
Judge Porter, we cannot hear you.
He's not talking, y'all.
We cannot hear you, Judge Porter. We're on FPOD. We can't hear you. I don't know if it's our computer or him.
I can't hear him.
One moment. I think that's what he said.
his computer was tempted. So.
Ms. Abels, are y'all able to hear me now?
Yes, sir.
All right. Are you Miss Brunson?
Yes, ma'am. I mean, yes, sir. I'm sorry.
All right, Ms. Brunson, the court is aware of the underlying facts in this case, also aware of your continued lies to this court on not one, not two, but on 3 different occasions. And you are likely to abscond if I were to release you from the detention facility. So I'm going to order your continued detention. Thank you, Ms. Brunson.
Hey, wait, can I just say, forget it.
Yes, Ms. Abels.
I didn't know till this morning she was there. And so I will make contact with her and see if we can get this worked out.
All right.
Merry Christmas, y'all. May I be excused, Judge?
Yes, thank you, Ms. Abels.
Thank you, sir.
That was it. I'm not sure what exactly going on. Yeah, that's it.
Judge, we're unable to hear you, sir.
Come on, Judge Porter, get this show together. You're making yourself look bad in front of Judge Kim.
Mr. Richmond, are you able to hear me? Okay, Jorge's shaking his head. All right. Iden Hagel. Good morning, Iden. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney. Is Mr. Daniels here?
Yes, I am here.
Oh,
Your
okay.
Honor.
Keith is here. All right. No, Harmony, I'm sorry.
Hi, Your Honor.
Is your attorney. Ms. Sherman was here. Is she still here?
I'm here.
There she is. All right. Iden, you were kicked out of Lake Granbury. You're level 1A today. I'm convinced that if I were to release you, you would reoffend. And so on that basis, I'm going to order that you be detained. Thank you, sir.
Thank you, Your Honor.
Thank you, Your Honor.
And now I can't hear anybody talk. Mr. Richmond, can you say something, please?
Yes, Judge. Can you
Okay,
hear me?
I can hear you. Okay, barely though. All right. Jeremy Hauser. Are you Mr.
Yes, sir.
Hauser?
Yes, sir, I am.
Mr. Hauser, the law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney. And Mr. Daniels, your attorney, is here. Do you see him on the screen?
Yes, sir, I do.
All right. You've been level 1-0 since yesterday. Mr. Daniels, what are your thoughts?
Your Honor, I'm not sure if you're aware, but he is in CPS care right now, and I'm not sure if CPS is here or not. But I did talk to Mr. Gorman, who is in charge of his case, and right now I know he doesn't have a placement for him right now. And I also, when I did talk to Jeremy, his conduct level had dropped in detention. I'm not sure where he is this morning, but I know he does not want to be here. But from what I have seen in the probation report, they are planning to do a psychological assessment and also a placement staffing, a resource staffing.
And Mr. Miller, has that psychological been scheduled?
Yeah, Your Honor, it's scheduled for Wednesday, the 23rd.
All right. And he is level 1-0 this morning, is that correct?
He is level 1-0, but he just made that level yesterday. He was level 3 confined back on the 15th for negative peer influence.
And who are those people in the parents' room?
Biological mother.
And
Jamar with our community, our kids.
okay.
I'm a caseworker.
Mr. Daniels, did you have any questions?
Well, if I could just ask Mr. Gorman what his thoughts are this morning.
I spoke to the intake specialist who's assigned to find Jeremy placement, and so far no placement has accepted Jeremy due to his behaviors. RTCs are reluctant to take him. They said the risk is too high. Foster homes, the same thing. Jeremy's ran away from placement, I believe, now 12 or 13 times. I believe this is like our 4th time here that he's been detained from running away. That's what the issue is, that placements, every time he runs away, he's getting involved with gangs now, more dangerous. So placements are hesitant to take him in.
May I please say something?
You may ask a question, but I don't think your attorney wants you to make a statement. But if you wish to ask a question.
Well, I wrote something for you.
You need to give that to your attorney and let your attorney evaluate it. Because if you make a statement here, while it cannot be used in an adjudication or disposition hearing later on, or even at a modification hearing, it might give the district attorney's office ammunition to use against you. And I don't think your attorney wants you to give them ammunition to use against you, do you?
No, sir.
All right. So do you have a question?
I do have a question, yes, sir.
What is your question?
You know, I know that I was a 3.
That is not that's a statement. That is not a question.
May I
What
please,
is your question?
do you think it'd be possible that I could get released on EM or extended probation or something? I just don't want to be in here for Christmas.
I understand that. You will need to discuss those options with your attorney, but your history of running away, I believe Mr. Gorman said in the neighborhood of 14 times, gives me great pause to believe that if I were to release you today, that you would either maintain level 1-0 at any placement that he could find for you, or that you would return and not abscond from the jurisdiction of the court. So because I believe you're likely to abscond, I'm going to order your continued detention. Thank you, sir.
Yes, sir.
Thank you, Your Honor.
Thank you, Mr. Daniels. Terrence Deshawn, Price Tucker.
Good morning, Judge.
Good morning, Mr. Youngblood. All right. Are you Mr. Price Tucker?
Yes, sir.
Mr. Price Tucker, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Mr. Youngblood, is here. Do you see Mr. Youngblood on the screen?
Yes, sir.
All right. The court previously found that probable cause exists to believe that you engaged in delinquent conduct sufficient to order your detention in this matter for the offenses of UUMV and evading arrest or detention. You were also on probation with this court. Mr. Howard, why was a drug test not administered on November 23rd?
I'm pretty sure it should have, Your Honor, but from what I've known, he tested negative.
The report presented to the court shows that when he was detained on the 23rd, he was not administered a drug test. Okay. Okay, so it appears that's just an error.
Yeah, that's just, yeah, it should be.
Okay, so he was drug tested. That's good. Hey, Mr. Youngblood, what are your thoughts?
Well, on the one hand, not overly serious type cases. On the other hand, he was on probation, and I'm sure it was a violation of his probation to leave home. And then, of course, he ran from the police, and those are factors against him. Factors in his favor is that he didn't test positive for any drug and that he is on level 1. Oh.
He's level 1 acceptable.
Yes.
Oh, it's okay. I misread that. So I'm considering asking the court to do an EM release.
Does he have a parent or guardian here today?
I haven't seen them, but there's so many people on the screen, I can't tell.
Your Honor, she
Mr.
called.
Howard,
She called today. She's not on the. I don't see her on the screen, but she called me today and said she'd be there. She's usually at every detention hearing.
Okay. Well, it appears I do not have a parent or guardian to release you to today, Mr. Price Tucker. So I'm going to order your continued detention. If you get back to level 1-0, then Mr. Youngblood, we can reconsider this. All right,
Yes,
that'll
sir.
be the order of the court. Thank you, everybody.
Is it okay if I say something right quick?
You may ask a
you don't
question.
need to say.
Yeah, I was asking a question.
What is your question, sir?
I was asking, I'm supposed to be back at level 1-0 tomorrow, and I was asking if I'll be level 1-0 tomorrow, will I get released?
It's not automatic like that. We will have detention hearings on Wednesday. Mr. Youngblood, if you can arrange for Mom to be here, and if Mr. Price Tucker is still level 1 on Wednesday, we can reconsider it then. All right.
Okay, well, I appreciate it.
Pinky
May I be
promise.
excused?
Yes, sir. Thank you, Mr. Youngblood.
Merry Christmas.
Hmm? No, okay. All right. Are you Mr. Promise?
Yes, sir.
Mr. Promise, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to an attorney, and Ms. Tillman, your attorney, is here. You also have the right to remain silent and not say anything at all. The court has previously found that probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your detention in this facility. The purpose of this hearing is to determine whether you should be released to a parent or guardian. Okay. The police report indicates that on November 21st, officers were dispatched to a robbery call and that someone had stolen a 2019 Chevy Equinox. They made contact with the victim who said she last saw her vehicle at 8 p.m. the night before at a residence. She woke up the next day and observed that her vehicle was missing. And she gave no one consent to use her vehicle at any time. Thereafter, police were informed that the vehicle had been seen traveling north on Campus Drive toward East Seminary. Officers located the vehicle and attempted to stop the vehicle. The vehicle began accelerating at a high rate of speed, even though the officers had their overhead lights and sirens on, and they were in a marked police vehicle. The vehicle kept evading. Eventually, while evading officers, a sporting 7.62 rifle, commonly called an AK-47, was thrown out of the vehicle. Ooh, this gets worse. Officers conducted a felony stop and removed you from the driver's seat. All right. You were brought into detention. You were administered a drug test on the 27th. The results were negative. That's good. You were unsuccessfully discharged from court-ordered substance abuse counseling at TYRC due to non-compliance. All right, Mr. Promise. I believe if memory serves, I was the one who sent you to drug treatment at TYRC. And so since that didn't go well, since you are on probation, put your hand down. You are on probation. Officers saw a rifle thrown out the window of a vehicle that was evading arrest. What was suspected to be a stolen vehicle. I am absolutely certain, beyond a shadow of a doubt, that if I released you, you would be a danger to the community. And I'm not about to do that. Put your hand down. So for that reason, I'm going to order your continued detention. Thank you, Mr. Promise.
Your Honor.
Can I say something?
All right. Thank you, Ms. Tillman. All right. Maria Angeles Rios Adorno.
Right here, Judge.
All right. How are you doing?
I'm doing
Rios
good.
Adorno.
I'm doing good. And you said my name right?
Well, that's once out of like 15 times I got it right. So I still got to work up to getting even close to right. All right. Ms. Rios Adorno, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Mr. Shaw, is here. Do you see Mr. Shaw on the screen?
No, sir.
Okay, Brad, say something.
Hello, I'm here. Got a blue plaid shirt on.
Oh,
really cool blue plaid shirt. All right. The court's previously found that probable cause exists to believe that you engaged in delinquent conduct, and we're really just waiting to transfer to Lake Granbury, and through no fault of yours, that transfer hasn't happened yet. So, Mr. Shaw, what are your thoughts?
Judge, it's my understanding that there's a bed open last Wednesday. You can talk to Mr. Alexander about this, but then the client has to quarantine because she was on a unit where somebody tested positive for 14 days. And so it's just, this COVID-19 just keeps whipping us.
Yeah, this is totally not her fault. In fact, you're doing well in the back, aren't you? What's your level in the back?
I'm a 1-0.
Uh-huh. And has been since when?
I'm sorry, what?
And how long have you been 1-0?
I've been a 1-0 for actually almost 2 weeks, and then I'm being honest, I lost my level last week, but I got it right back. And I would really want to go home on an EM for Christmas, at least.
I know, but if I let you go home, you would have to come back into detention for a whole new 2-week period.
Yes, that's fine.
And no, it's not fine, because that just delays everything. And you have finally gotten in the right mindset. I remember our conversation last time about you being ready to go to make the best of this at Lake Granbury. You're going to go do the program. You're going to get out. You're going to be awesome. And with you in the right mindset, I don't want to delay this. and it's looking like that she may get to go next Wednesday. Is that correct, Mr. Alexander?
So as we stand now, we're just waiting for the quarantine to be lifted off of FPOD. As far as the placement at this moment, because this could change in 10 seconds, at this moment, the placement is good. We're just waiting for the quarantine on Fox. So whenever that's raised, I believe will be next week. She should, at this moment, be able to go next week. But I want to piggyback what you said, Judge. I talked to Marty Angelis almost daily in the last couple of weeks because of the up and down with the placement. She is in a much better place. The up and down, the constant could go, not go. We've been dealing with that, me, her, and her mom, and she's doing really well with it. She did lose her level last week, but it had a lot to do with the constant inconstants of what we're doing right now. And she was just upset and bothered because one day she's going, the next day she's not. Later the same day, she's back to going. And she's handling it very well as opposed to where we were 3 weeks ago or a month ago. So, and I also was told her physical expired. So even if she were to get released, she had to come back even earlier to do a new physical that would have to go with her when she goes to placement. Because her physical for the placement expired, I believe, last Thursday.
Okay. But we can get that rescheduled between now and Wednesday of next week, right?
It's done in detention with Nurse Lynn and the detention nurses.
Awesome. Ms. Rios Adorno, we are not trying to punish you. Completely the opposite. What Mr. Alexander is saying and what I've been saying is we are so incredibly proud of you for the amount of maturity we've seen in you over the last 2 months. I've seen some real growth on your part. And so I just want to keep saying that of how proud I am of you. And I don't want to keep you in detention to punish you. I'm doing it because I actually want to shorten the amount of time it takes for you to get to Lake Granbury and for you to get back from Lake Granbury, okay? Does that make sense? I know it seems unfair because you're doing everything right and it feels like you're getting stuck in detention. And we all know it's not your fault that you got delayed going to Lake Granbury, right? Okay. I want you to remember how proud Mr. Alexander is of you, how proud I am of you, of the growth you've shown, okay? All right. So I got to order you be detained today. That'll be the order of the court. I'm sorry.
Judge?
Yes, ma'am.
I know I'm asking for a lot, but is there any way that we can arrange for me to speak with my daughter?
Yes, we can. JPD, can we allow Ms. Adorno to have a phone call with Ms. Rios Adorno?
Thank you.
Judge, they're on full quarantine. They're not allowed to receive even probation officer calls, only attorney. The only suggestion I have is after detention hearings, if you'd like, she's the last female, you can do a room for her and her mom, breakout room, before I put her back down.
We will do that.
Yes,
Thank
sir.
you.
All right.
Thank you, Judge.
Okay. Jakiah Smith.
Your Honor, I'm covering for Mr. Victorson. The mom says she's in the waiting room. It's Miss Webster.
Okay. All right, Mr. Smith, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Mr. Adeniji, is here today. Do you see him on the screen? Lateef, if you could say something.
Can you see me? I see that. Good.
All right. The court has previously found that probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your detention in this facility. You're currently level 2-0 in the back as of this morning. Mr. Adeniji, what are your thoughts?
My thoughts for him to be allowed to go home, spend Christmas with electronic monitoring. We're coming back to court, Judge.
I believe on the
5th?
On the 21st of January.
Oh.
I believe they are looking for placement for him.
Mr. Smith, did Judge Kim go over the behavioral levels with you at your initial detention hearing? No? Okay. Do you understand the different behavioral levels in the back?
Yeah, yes, sir.
What's the best level?
1-0.
Level 1, outstanding, right?
Yes, sir.
You're not there yet, are you?
No, not yet.
All right. Okay, you got to get to level 1-0 before I can consider your release. Because you're not there, I have to order you be detained today. All right, that'll be the order of the court. Thank you, sir.
Judge Porter, is that only for Judge Kim or also for you and every judge?
That's for me and every judge.
Just making sure.
There's sometimes when we don't get to level 1-0 and Judge Kim puts us in detention too.
Oh.
Y'all just don't hear about it. Yeah. Court coordinator sitting next to me and she says we get put in timeout. It's funny because it's true.
Okay, Judge.
All right.
Am I released?
Yes, sir. Happy holidays, Mr. Adeniji.
Merry Christmas, Judge.
All right. Banquez, Jaleel Thomas. That's a cool name. That's a good, strong name. Oh, Dusk. I skipped one. Okay. Are you Mr. Sato? Let's get you unmuted.
Yes, sir.
All right. Mr. Soto, my name, is it Sato or Soto?
Soto.
All right, Mr. Soto, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney. And your attorney, Mr. Adler, is or was here. Is he still here? There's Mr. Adler.
Morning, Judge.
All right. The court has previously found that probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your detention in our facility. You've been level 1-0 for the last 7 days. However, you have a history of running away and removal of your electronic monitor. Mr. Adler, what are your thoughts? I can't hear you, Mr. Adler.
Can you hear me now, Judge?
Can you hear me now, Judge?
There
How
we
about
go.
now? Sorry. Thanks, Judge. Basically, Judge, just try and give the young man one more chance on the electronic monitor. He has been 1-0, I think, for the last week or the last 7 days. And I would also defer to Ms. Guerrero if she's on the line and see what her thoughts are.
Actually, I'm covering for Mr. Reyes. He's on probation with Jose Reyes.
All right, Ms.
Yeah,
Lopez.
sorry.
Well, Your Honor, I have here the same request that if possible, would the court allow him to go on EM? He turned himself in after cutting that monitor off. He's on probation until November 17 of next year. It appears the parents are there, Your Honor. I understand they're Spanish speaking.
He's on probation for theft of a firearm?
Yes, sir.
How long was he on the electronic monitor before he cut it off?
Honestly, Judge, I do not know that. Try to figure it out here.
Almost 2 months.
Pardon?
Almost 2 months, sir.
Almost a month, he said.
2 months.
2 months.
Yes.
Who said that?
The client said that. Yeah.
Oh, okay.
I'm the father. Please.
And when he came in, he was positive for marijuana.
Yes, Your Honor.
All right. No, I'm sorry, Mr. Adler. I'm sorry, Ms. Lopez. I'm not yet convinced that if I were to release him, that he would not be a danger to himself as well as the community. Judge Kim obviously had a reason for ordering him to be on the electronic monitor for that length of time. Obviously, Mr. Soto, while he was willing to accept the conditions of probation, he decided he wanted to unilaterally change those conditions of probation. Mr. Soto, that's not the way this works. Probation is an agreement between you and the court that you will behave in certain ways. When you violate those conditions, you're actually breaking your promise with the court. When you break your promise to the court, then the court doesn't have any reason to believe that your statements to the court that you will in the future abide by the conditions that you agreed to have any merit. And while you've been level 1-0 for 7 days, you should have been level 1-0 for much longer than that. Now I realize the reason you dropped to level 2 unacceptable is because you fell asleep in class back in detention. However, that doesn't change the fact that you cut off your EM and you're using drugs while you're on probation. Not acceptable. And so at this moment, I believe that if I were to release you, you would go back to using drugs and cutting off your EM. Mr. Adler, I believe that Dad wants to say something.
Yes, sir.
See,
¿Puedo hablar?
Can he talk, Your Honor?
sí, se puede hablar.
Thank
Sí,
you.
señor.
Él lo intentó por mucho tiempo. Él no usó, he tried to not use drugs. He tried really
Hey,
hard.
sir, you're not helping your son by making excuses. Say something else, please.
Well, yes, I love him. So está bien.
Thank you.
Never mind.
Lo siento, es que no lo estás ayudando a su hijo dándole excusa al juez. No quiere oír excusas.
Señor.
Mejor es decir la supervisión que le va a dar al niño cuando regrese a su casa y que vas a hacer ustedes para que él nunca use drogas y nunca corte el monitor otra vez, ¿ok?
Gracias.
Gracias, señor. Perdóname que te tuve que hablar así. I'm sorry, Judge.
No, it's fine.
No, so está bien. All right, Mr. Soto, for today, I'm going to order that you be detained. Maintain level 1-0, and you'll give me reason to reconsider that next time, okay?
All right, yes, sir.
Thank you, Judge. I'm sorry.
Not a problem, Mr. Adler. It's good that the dad has an opportunity to ask questions. All right.
Thank you, Judge.
Dockets, Jaleel Thomas.
Yeah, that's what happened. Thank you.
Are you Mr. Thomas?
Yes, sir.
Mr. Thomas, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to an attorney, and Ms. Mills, your attorney, is here. Do you see her on the screen?
Yes, sir.
You also have the right to remain silent. The court has previously found that probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your detention. You're currently level 1-0 and have been since the 9th of this month, so for about the last 12 days or so. But you do have a history with the department, including a history of removal of your EM. And when you came in on the 6th, you're positive for marijuana and you have a history of marijuana. So, Ms. Mills, what are your thoughts?
Your Honor, he has been level 1-0 for quite some time. I will also point out he was initially detained because he fit the description of something, but none of those charges have been brought in. So right now he's just on a technical violation. I do know that he wants to go home. He's been on his best behavior, like you said, since the 9th, has had no problems that I know of. And so we would ask that he be able to go home today on an EM.
Judge Porter, at his initial detention hearing, Judge Kim ordered a placement search for behavioral issues.
Back in November 20th, he initially refused to go to substance abuse treatment. Is that correct, Ms. Campos?
Yes, and I did tell Judge Kim at our initial detention hearing on the 6th that I could get him a bed over at the campus. In fact, I did secure one and his bed was available for today, but Judge Kim did not want him to go to the campus and he ordered a placement search, and placement is actually actively looking for a placement currently for Vonquez.
Oh, and he's on probation for UCW, right?
Yes.
And that's a weapons crime, is that correct?
It was a firearm.
And then his new pending referral that Ms. Mills talked about that has not yet been filed is possibly related to another firearm, is that correct?
Yes, Arlington Police was called to a shooting in progress call.
All right. Well, Mr. Thomas.
Before you say anything, can I just make a statement?
Can you interrupt, Ms. Thomas? Can you interrupt? Is that what you're about to ask?
I was, yes, sir.
All right, please go ahead and interrupt. I didn't mean to be talking.
I wanted to let you know that he was a victim of that, what they're talking about. He was actually in the house that got shot up. It's just that he came outside and was trying to leave, not making excuses, but he came outside and he did run from the police, but he was a victim. He was not doing the shooting. That's all I wanted to say.
Okay. Well, then if that is correct, then Ms. Mills has a lot of good information to work with in the event that the DA decides to file that new case. It sounds like the DA's case may be a little weak, but that's a decision for a later date. The fact still remains, though, that you haven't been real cooperative with Ms. Campos, and Ms. Campos has to be one of the best field officers we've got. She bends over backwards for the kids that she works with, more so than Judge Porter would if Judge Porter was a probation officer. She gives y'all try after try after try, and Judge Porter would cut y'all off a lot sooner than she does. So the fact that you told her no, not probably repeatedly, that doesn't hold well for you, Mr. Thomas. So I'm convinced that if I were to release you today, you would cut off your EM, you would go smoke dope, you would be around weapons, I don't know. But as of today, I'm going to order that you be detained. Thank you, sir.
Yes, sir.
Judge.
Thank you.
All right. Is Miss Herrick here? She has not come back. Oh. Okay.
I tried reaching out to her, the office, but it said she was unavailable when I tried to call.
Thank you, Mr. Nava. All right. There's a provision in the Texas Constitution about the courts of the state of Texas and that they are to be open to the public. However, the Texas legislature in its wisdom has provided an exception to that. It's found in section 5408 of the Texas Family Code, and that provides that when a child or children are under the age of 14, there is a presumption that the child's right to privacy outweighs the public's interest in participating or observing any hearings involving a child or children under the age of 14. Any remaining detention hearing or hearings that we have this morning will concern children under the age of 14. There's been no evidence brought forth to the court that shows that the public's right to participate in those hearings outweighs the presumption that children under the age of 14 have to privacy. Accordingly, the court will close any remaining hearings to the general public pursuant to Section 5008 of the Texas Family Code. I thank everyone who may have been watching these detention hearings. And I'll remind you that rebroadcasting, recording, all or part of any of these hearings is expressly forbidden. Violation of the court's order may
Judge Porter, were you talking to me? Is that who you were talking to when you said that? I bet it was. Anyways, guys, I so appreciate you being here tonight. Oh, I so appreciate you being here tonight. I hope you had a wonderful evening. That was our first ever bingo, like official bingo. It won't be the last. We have many more to come. We have lots of fun to have. I will be in court watching tomorrow with you, trying to find some new clips and also get some other stuff together. And then I'll be back tomorrow evening around the same time. So if you won in bingo, I want you to go ahead and post a comment in this video down below. Tell us what you had in the bingo card, and I will make sure to like those comments and give out some extra points within the Streamlabs thing. Anyways, guys, I thank you so much for coming out tonight, and please make sure to subscribe if you're not already subscribed, like the video, check out Time Served, Credence and Mikey, Looking at Legal Stuff, the whole gang, please and thank you. I hope you have a wonderful evening. I'll talk to you tomorrow. Bye.